Welcome, my little couch potatoes, to the comfiest courtroom on the internet. I'm your host, Llama, and it's time for dramatic testimony, overruled objections, and absolutely unqualified opinions. So grab your snuggiest blanket, some delicious snacks, and get ready to watch court with your internet besties. This is Couch Court with Llama.
Hello, happy Fukong Friday, Couch Potatoes.
It's Fukong Friday.
Fukong Friday, thank God, because this week, every day has felt like 3 days in one, every day.
It's true. It's true.
Thanks, Packy. Good morning to you. Good morning. Oh, my eye. There's something in my eye and it's driving me crazy. So it's
It's your
just going to be
finger.
like this all day. It's my finger. Oh, my gosh. How did I not? Text packet says, can you go back to the last one, Lady in Gray? $83,000 raised for Mike Maricini so far. Amazing. To watch all of that happen yesterday with the fundraiser. I went on Echo Stream last night, which is another reason why I'm tired. I partied all day. All day was a party. No, it was a great time. But that's amazing. Amazing amount of money raised for him. Also, I mean, we're still raising money over here. We got the QR code up there that you can donate to Mike Maricini's GoFundMe. Link in the descriptions, link in the chat all day. There's so much money that still needs to be raised for him. So let's do it. We also have our June fundraiser that we're going to be doing with everyone. We've gotten some people already locked in, which I'm so excited about. Hold on. How do things work this morning? There we go.
It's our first day.
It's our first day. No, we got so many people that are already signing on, that are already donating items for the auction. And it's going to be a big deal, 12 hours. And Maria's like, Llama, how are you around all day yesterday? This is how. This is how I can be. So we're very excited about that. If you're interested in helping out anyway, whether you want to be a guest, you have auction items to donate. Sorry, my little stupid box thing. Ugh. Elbow feet. Somehow, even under the desk, he makes like a chaos disaster zone with his feet. I don't understand how it happens, but if you're interested in helping out with this fundraiser, please email me this weekend, Tara, Tara, at tcwtmedia.com, or you can get a hold of Winks. Both of our email addresses are at the banner at the bottom. Even if you're not like a full-on content creator, maybe you're behind the scenes, we want to have you. We want to talk to you. Or if you're an advocate of some kind, or I don't know, maybe you just want to give a message to Mike. I don't know. Email me or Winks. Winks is Winks, WINKS 5813 at gmail.com. Anyway, we're really excited about that. That's what I get to do this weekend. After tomorrow, was listening to Stephanie's new interview. Oh, yeah, I haven't listened to that yet. Tomorrow I have to go to my son's high school orientation at 8 in the morning on a Saturday. Like, what have we done to hurt them? Are you serious? Ugh. Ugh. So it's going to be fun. Yes, if you haven't yet, please you're on mute, babes. Hit the like button.
It's before 7 a.m.
After 7 a.m., but it's going to feel.
I said you sounded a little bit like Laura. That was my point.
It's inappropriate. It's not even business hours. It's a Saturday. Oh, thank you, Val Marie. It was a lot of fun. They were lovely to hang out with them and just chill. But yeah, so I got that to do this weekend and all the other stuff. All right. So yesterday was a little bit short of a day for us, but it was interesting nonetheless. We had another blog by David, which was, I don't know why we needed to know about his dramatic experience at Dr. Phil. Nobody even told him how to prepare for questions, Buffy. How rude. They were ambushed. He was nervous because he didn't know what to expect.
He's used to getting full discovery.
I know, right? Like, oh, what? What do you mean I don't have all the questions beforehand? It's scary. And then he wrote a motion to compel lunch to the judge, which was ridiculous. Never seen a document. Never seen a document like that ever. Ever. Like, what was that?
It was a lot of gall and audacity, if you ask me. And also a lot of pick me.
A lot.
Like he likes to be, it sounds like very center stage.
Yes.
Very
much so.
Syndrome.
Very much so. He's like, Your Honor, they won't like answer my phone calls anymore, and I'm gonna need you to order him to have lunch with me.
I can't imagine why they don't want to talk to you after 39-page motion to extend.
Right? And Woodnick, and one of the things he filed that we read recently was just basically like, this guy's a fucking dick. He's a dick. He's mean. He's harassing us. He's very aggressive,
Also,
threatening. He's
having a
threatening.
conversation, I feel like would like make your client's court call or attorney fees go through the roof, because I can't imagine he's short-winded on the phone.
No, definitely not. Definitely not. Everyone that, as someone who's worked with DP's producers, Dr. Phil's producers, everything David says about that is complete crap, in my opinion. I mean, yeah, also, it's not like it's that serious. You're a lawyer. Like, you should just be always ready, like, for defending your client in whatever way. I mean, what? I mean, yeah, everybody gets nervous, but he had to brag, humble brag before about how he had been on TV for so long.
It's not his first day on television.
Right? Say Cheese says, I've never seen that in 30 years of practice. David is unhinged. Judge Greg won't let me sit at the cool kids table, and it really hurts my feeling. Just my one feeling. So that was an interesting read. And then we got into Laura's bar complaint against Greg Woodnick that she had filed in January, which we already knew about because we did read a little her letter to the bar about him and hi Wings, her and I'm sorry, him and Lexi Linville, her attorney, because she filed a bar complaint against both of them because she felt like they were conspiring against her for trying to get her to sign an affidavit. She was never pregnant, and Laura would never commit perjury, ever, ever. So she was not going to sign
Ever.
that and commit perjury, you guys. So that's where we are. We're gonna get back to reading her points of telling the bar the rules.
Yeah.
that she
That's
got off-
right. That's where we left off.
That is where we left off today. Is reading her stupid reasons why she think Greg Woodnick broke the bar rules. She's gonna make lots of suggestions to them. And then after that, we have some grantings from the judge about a few things that we'll go over. And then we're going to have Woodnick's response and objection to David's motion to compel ledge. And there's a lot in there, including emails. Emails. And I think the second list of exhibits is a social media.
Oh, goody.
So, I'm sure they're all very nice and well worded. And David is just a stand up guy. So it's fine.
Oh.
I'm sure. Also, today is we got two birthdays in the house today. We got Katie 4296 and I'm some lady whose birthdays are today. So happy birthday to them. If you see them, tell them happy birthday in the chat. I have their names down here on their little banner. Echoes, is it morning already? Right. I know. Thank you again for having me on last night, Echoes. It was a lot of fun. You and Jeep Daddy were very sweet and it was great. It's just like hanging out with some friends. I love it. I'm all about casualness. So anyway, make sure you say happy birthday to them. Oh, speaking of, there's Katie. I see her popping in there. You're welcome. You're 48. Well, and I'm sure fabulous as always, right? So happy birthday to you, babe. Oh, we are color coordinated today. We didn't even plan it. I was
We
about to
didn't.
hit the live button and I was like, oh my God, we're wearing the same color today. And I was like, this is what I wore
Wasn't.
to bed.
And I'm like, I just threw this on this morning over the t-shirt I wore to bed.
Right? So it happens. We were just like, we are twins. So, you got that connection or whatever.
That's so funny. I logged in this morning. My name thing still said Baby B. I was like,
I
yeah, I'm
love
gonna
it.
change that.
We should get baby A and baby B shirts, I think.
That would be so funny.
And that ultrasound that you guys made for the thumbnail where we were in there. We should get shirts for that. Oh man.
I
That'd be
would make a
amazing.
shirt for everything.
I know, right? Oh
I
gosh.
love t-shirts with stupid sayings on them.
Me too. Well, before we get into today, let's go over just a few of the comments that were left on our video yesterday. User QQ said the Dr. Phil story is funny. I hadn't heard it before, but it seems so jingrous from what we know of him. First, he apparently thinks people will be impressed. Yeah, he definitely starts off everything that way, doesn't he? Second, he seems surprised that it was an ambush rather than carefully scripted. Exactly. It was an ambush. I know we were probably only going to be on for 20 minutes, but it was an ambush. Oh wait, I already read that. Third, his position is that the dirty wasn't legally responsible, but they were still profiting off a site that allows that stuff to be posted. So I think it's fair to say that ethically they have some responsibility. It's just like David's position on Laura's case. He's upset that his legal technicalities didn't get her off, but almost everyone else is happy because they feel justice was done. That's true. You ladies need Pod Scum Posse avatars. Yes. Good morning, Bruce. Ahoy, Bruce. Yes, we do. I want to know how Laura appreciated Mike's fundraiser on her birthday. It's funny how a ton of people donated $36. It's so funny. I'll
That
tell
is
you,
funny.
when we saw the wit of everybody, hi, Amos, we were like, these are our people. They too are snarky as we are, and we love it. And then boring tax lady said, David's sign in the thumbnail sent me. Yes, Buffy makes her thumbnails. She does a great job.
Well, you
capturing.
can kind of see how I'm starting to spin this, the spiral of insanity as we went through this story. Like they all start out good, and then I just start.
It's crazy.
Yeah, I'm just like, what the hell? This is going to be funny. Or I'm just, it is what it is now. It's like, yeah, whatever. I
know,
tried to be professional at first, but now it's just too weird.
It's too weird, right?
It's too weird.
You just gotta right off the gate be like, what? What does he mean when he went to lunch? This is weird. Well,
My
it's real
thumbnails
life,
are becoming unhinged as the story becomes more and more unhinged.
right? She made one for Thursday, but we covered the stuff needed. I can't wait for her to use that thumbnail, though. That one's probably one of my favorites. So we'll have that one sometime soon because it fits many shows since David's around. And then Jill PX said, just went back to watch the beginning of the stream because I was late joining. I loved your reading of the Dr. Phil appearance. He's just so damn proud. And Buffy, you have surpassed yourself with this thumbnail. Also, if you haven't watched the episode, you should. Dr. Phil never realized David was right because he was disgusted. So lots of wonderful comments about Buffy's thumbnail. If you're part of the replay crew, go ahead, leave comments on this video, and we will get to them on Tuesday's show. And over the weekend, we read them, we love them, we respond to them at some point. Sometimes not right away. We do, though. But please leave any comments. Also, replay crew people, you get a special little button. You'll get a hype button, which gives the episode hype points that puts you in the algorithm better or something. I don't know. It's really important. So if you're watching this as a replay crew, please hit the hype button, boop, and give us some hype points. It's very much appreciated. Now, let's get into today. Let's get our starting costs for today, which I don't think I did this right. I didn't. I didn't update it from yesterday's. Well, I'll just tell you guys, because those numbers aren't correct at
We
all.
threw her off, Echoes.
I know. No. This is what I get for it. I did this with this. I did this with True Crime and Wine Time. I thought I finished everything, and I was like, "Pah, I did it." Oh, yes, it is. The hype button is only for the replay crew. I don't know why. It just is. I think it's also only on phones.
Yeah,
I don't think
I'm
it's
not
on.
really sure, but I
It's
know
not on the
like it
PC.
doesn't show up until the stream is over because the video has to process to be put.
Yeah,
Like it doesn't hype until it's for videos, not for live streams. So
right.
once it gets done, the live stream gets done processing, then it shows up. So
Yeah, so if any of you may be watching us today, go back over the weekend, just click on it and just be like, boop, hype. All right, so the starting cost of Clayton's legal fees at this point in the timeline is $65,000. All right, $65,091 specifically, which is, I know we say it every time, it's a whole lot of money. It's a whole lot of money for a whole lot of us. So, sorry.
yeah, I couldn't pay it.
No. All right, so let's get into Laura's bar complaints
I would be crying.
and all the violations.
If that was the bill I had.
Right?
Like the only time I've ever owed that much money was for a car in my house. That's a lot.
Well, and for something that's such bullshit and completely made up. It's not like other kind of suits where, well, maybe you were in a contract together or something, you know. This is all fucking bullshit. All of it. $65,000 to fight some bullshit. And that's crazy to me. Absolutely crazy. And spoiler alert, it's going to get so much higher because of David. Oh, you know what, Buffy? Last night, well, you did say you watched Echo Stream this morning, but I don't know if you heard Laura say David in the bankruptcy hearing part, but we say it just like she does. David.
Oh yeah,
David.
I watched it. I heard all of it. I also heard you said that I was very scary.
She is.
And I was going to be you're like, she's going to be so mad at me. Buffy is so scary. And I was like, I am not there to defend myself.
No, Buffy is not scary. And she would never yell at me. She never would do those things. I mean, blink twice for help. No, I'm just kidding.
I'm not making her say that.
Good morning. There's another
Happy
birthday girl. Happy birthday, Anna, some lady. No, she never yells at me. She's very lovely and nice. I know. I've been friends with her for like 3 years. So I can vouch. She does keep me in mind though. She'll be like, all right, it's 3 minutes to showtime. Where are you, Llama? Where are you, Llama?
I will. I will be like, you good?
Right. Oh, she'll be like, or the night before, like when I'm doing trials, she was like, girl, remember, you gotta be on at 8 o'clock in the morning. It's so cute. I love it. And I'm like, yeah, I know, you're right. You're right. She's like my conscience on my shoulder. I'm like, damn it, Buffy. You're right. You're right.
Like, Llama, maybe don't drink that much on True Crime and Wine Time. We have to be up at early for Friday. Okay, Mom.
Okay, well. And then I'm due. And then in the morning, I'm like, damn it, Buffy. You're so right.
And I'm like, damn it, Llama.
Right? You know me too. We know each other way too well. Okay. So let's get back to Laura's complaints. Let's see. We left off on page 85. And oh my gosh, I forgot about these. These are so dumb. She has pages of these. Like, do you need to do this when you write to the bar?
She feels like she does.
Like, I don't know if it's required or not. I'm going to go with
That's
it's
why
not.
the bar was like, yeah, these quotes all just came from your motions. You can literally say anything in emotion. Yeah, it's emotion.
Right?
Like,
You think they all ran?
like
Like,
you
I
can
feel like
literally say anything. You can make any claim. You just have to be able to back it up later. But you can say anything in emotion. We've seen it
right,
happen
right.
even in criminal stuff.
It's true.
Where the prosecutor like writes up their like probable cause affidavit and make all their stuff, and none of it turns out to be what they're presenting it as in the motions.
I've seen that quite a few times.
Mm-hmm.
I feel like anybody who gets there's the birthday twins. Um, I feel like anybody that gets anything from Laura immediately reads it and is like, "Oh my God," and then shows it to everybody. Be like, "Guess what I just got? Read this
Right?
nonsense."
How
Because it
can you
really is.
not?
Right?
If
It's
I
a
had
whole
anybody in my family that cared as much as I do about this stuff, I'd be like, look at this shit.
right? We ever get one, we're framing it, we're putting it up in our houses. So when somebody comes over, be like, "This is my biggest accomplishment.
I
Look at
gotta
what I
cease and desist.
got." All right, so let's get this. We'll rotate again like we were doing. This goes into Laura pointing out all the things that she thinks Woodnick has violated to the bar, and it's very funny. So, accusations of deceptive court behavior. Petitioner then appeared in court wearing an ostensibly fake pregnant stomach, furthering her fraudulent narrative. Potential violation Rule 8.4D for claiming without substantiation that I engaged in deceptive behavior in court, prejudicial to the administration of justice. I did not appear with a fake pregnancy stomach. I am is not a liar.
I am is not lying.
That is my new favorite
See,
thing to
and that's
resell.
another shirt. Like I've got a list. I'm just
Girl,
gonna
write 'em
make
down.
shirts.
Yeah, we got a whole merch store. Go for it. I am is
I am is not lying.
right. All right.
Am I doing the next one?
Yes,
Are we
ma'am.
alternating? Okay.
Yes, ma'am.
Bad faith litigation. Full quote. Petitioner's baseless accusations and myriad of filings have harmed him. Potential violation. ARPC Rule 3.1 regarding meritorious claims and contentions by suggesting my legal actions lack legitimacy without evidence. I don't even know what that means.
I don't either. Accusations without proof. Petitioner's factual contentions, assertions of pregnancy not supported by any verifiable evidence from the onset of this action. Potential violation ARPC Rule 1.0 on maintaining integrity by accusing me of lying without presenting clear evidence. So rude.
Okay. Claims of unreasonable filings. Really?
The irony for her to be like, this is ridiculous. Let me send you
Petitioners,
94 pages, bar people.
my filings are not unreasonable. Petitioner's repeated filings, including a motion to dismiss once she alleged she was. Ma'am, you need to proofread. This is incredibly hard to read.
Yeah.
Petitioner's repeated filings, including a motion to dismiss once she alleged she was no longer pregnant, being unsupported by existing law. Potential violation ARPC Rule 3.1 on filing non-meritorious claims and contentions by alleging my motions are baseless when they are not.
They're not.
How dare they? I wanted to dismiss the case after I had a miscarriage since there was no longer paternity to determine.
Which is hilarious because she doesn't even say when it actually happened. And so, okay. So where did the bump go, right? You wanted to dismiss it after you had the miscarriage, which Corey, your lawyer, said it ended up being September and October. So you mean ridiculously hard to read. That it is. Yeah, okay. Okay, that makes so much sense. Excuse me. Offensive and speculative remarks. If impossible from oral sex, Laura was actually pregnant, delivered twins, and or suffered a miscarriage post 24 weeks gestation at any point during this proceeding, she would have verifiable medical evidence. To date, no fetal death certificates have been executed, no confirmable medical evidence has been presented, and Laura has continued to claim protection while reaching out to the media directly. Potential violation ARPC Rule 8.4D. Suggesting conduct prejudicial to the administration of justice through speculative and offensive remarks regarding the outcome of a pregnancy. This comment not only trivializes the serious matter of pregnancy and potential loss, but also ventures into making unfound and speculative assertions about highly personal and sensitive circumstances without any substantiating evidence, which could be deeply distressing and seen as an attempt to demean and harass you guys. And as stated before, Mr. Woodnick was not there the night that Clayton and I hooked up and cannot make it seem like a fact that we only had oral sex when that is not the truth. You guys, they're just making her look so bad. It's so embarrassing for her. She's so embarrassed. Okay.
Sweet liege, you are a mortician?
Oh, really? Oh, that's interesting.
That is so interesting.
Oh, you're a mortician. You're in Ohio too? Me too. Look at that. I follow quite a few more morticians, actually.
I know. I do too. That's why I was like, oh, I'm so intrigued.
Very interesting.
Why are we so morbid?
About it, sweet liege.
Why
I mean,
are
it's
we
morbid. It's going to happen to literally all of us. So I don't think it's that morbid. Your sleep score last night is lower than Laura's HCG count. Me too, babe. Me too. Right. 43 P6. Isn't that enough? Should be enough. All right. Moving on. Some more dumb reasons.
Inflammatory and disrespectful remarks. Full quote. For all respondent knows, the imaginary twins are buried in a horse ranch. Potential violation. That was mean. ARPC Rule 8.4D, suggesting conduct prejudicial to the administration of justice through the use of insensitive, I said use mean, insensitive and speculative language about a highly personal matter.
It's like the third time she's brought it up too. All right. So then she doesn't even title these next ones. God,
no, I think they all fall under the same category.
Oh, is that how she's doing it? Well, she doesn't do a very good job of anything. Her entire petition was predicated on either lies or delusions and mirrors prior litigation involving Miss Owens and a growing list of other victims. Potential violations. This rule prohibits conduct involving dishonesty, fraud, deceit, or misrepresentation. Mr. Woodnick's definitive statement that my entire petition is based on lies or delusion directly accuses me of fraudulent and deceitful behavior. without prefacing these allegations as opinions or unproven claims. How would people tell the difference, you guys, without him saying it's just hypothetical or whatever? His failure to use qualifiers like allegedly suggests an unusual certainty and these serious accusations, which could be seen as a direct attack on my character and integrity, you guys.
Okay, but it's a motion. He doesn't actually have to write allegedly because he is making the accusation because it's do you know how court works? You've been involved in plenty of them.
Right? The men that he refers to as my victims are men that I have orders of protection against. So she didn't do anything wrong. How dare he?
God, this is so frustrating. Meritorious, she likes that word. Meritorious claims and contentions explanation. Attorneys must not bring or defend a proceeding or assert or controvert an issue therein, unless there is a basis in law and fact for doing so that is not frivolous. By stating without qualification that my petition is based on lies or delusions, Mr. Woodnick not only dismisses the legitimacy of my claims without a fair evaluation, but also implies that my legal actions are entirely without merit, potentially misleading the court. I thought that was kind of the gist. She acts like this is not how court goes, and that's what I can't get past. Like this,
she doesn't
this
like
is
it.
how it goes.
She just wants to rewrite all the laws herself.
Clearly.
I mean, that's how it seems to me. Rule 3.4E, fairness to opposing party and counsel explanation. In case you bar people don't understand. This rule underscores the importance of respect towards the legal rights of others.
There's your Chat GPT buzzword.
The direct and unqualified manner in which Mr. Woodnick discredits my entire petition goes beyond legal argumentation into the realm of personal vilification, which is contrary to the spirit of fairness and civility mandated by the ARPC. Okay.
There are certain words
Okay.
that make me go, yeah, that was definitely Chat GPT.
Is that
Paints the
true?
picture and underscores.
Is that true, MK? There's a
That
whole,
wouldn't surprise me.
I mean, it wouldn't surprise me either. I don't think it's true. I think they're
You
just,
can do all kinds of things with your old pregnancy test. You can make a necklace. You can frame it. I've seen people put it in a cake. It's gross.
in
Like
a cake.
Yes. Yeah, it's weird.
Oh,
People do weird things with their old P tests.
like, is it for like the baby shower? Like, what kind of cake are we talking about?
They use it for like announcements.
Oh,
You know,
yeah.
because people will keep it to themselves for a while, but they'll like put it on a cake and serve it to their husband. You haven't seen those things where people's like,
No.
I hope he's not eating that. Anyway, it's gross.
Oh my goodness. Yikes.
Oh, you saw Sean. Sean knows.
Sean, no. Oh, okay. Well, I mean,
There's people do some things with their P tests. Just saying.
That's weird. I thought blowing out candles on a cake was gross. Nope. It can be grosser. Amy says, I put mine in a scrapbook, but I'm feeling Josh to remove it. No, I think putting them wherever you want is fine, just not in food. Definitely not in food. That's a hard no and weird.
You saved your pee for a very long time.
Yeah.
Amos. That was a very long. I'm just teasing you. That's for the face picture.
Gross. Oh my goodness. Okay, so next, rule 4.4a, respect for rights of third persons. right? Nobody's respecting Laura, guys. Explanation. In representing a client, a lawyer must not use means that have no substantial purpose other than to embarrass, delay, or burden a third person, or use methods of obtaining evidence that violate the legal rights of such a person. Mr. Woodnick's assertion about my petition being based on lies or delusions can be seen as an attempt to embarrass and burden me rather than a constructive legal argument. Yeah.
No.
What a dick. How dare he? Like the audacity of her to be like, to embarrass me or to delay things, says her of all
Girl,
people.
just wait till you get on the stand in a criminal court. They are going to embarrass the shit out of you. They do not care.
Nope. Nope. Oh my goodness.
Remember that trial where they just flashed that dude's naked picture in the middle of court?
Opening
Like,
statement. And we were like, oh shit. Was
we
the
were
opening
like,
statements,
whoa.
remember?
Yes.
We're like, that's a whole ass
They don't
dick.
care. I was like, oh, I'm going to have to blur that later. That
Right?
was nobody was prepared for. But yeah, they don't care. They'll embarrass the crap out of you. It wasn't even the defendant. It was her boyfriend.
Right.
Her boyfriend's son.
Her boyfriend / stepson
Yeah.
/ victim's son. It was all very weird.
It was
and
weird.
confusing. The Devin Michaels trial is what we're talking about. But yeah, in opening statements, they put one of the sexy pics that he sent her up there with his wang out. All right.
And it was not blurred on their end. I had to blur it on my end.
That was a wild day. I remember it just being like, was that what we all just saw? It sure was. Sure was.
Yep.
Preparing for the bar complaints against the prosecutor, right? She's already working on it. These motherfuckers. One of these days, they're gonna.
Okay, where are we at?
Rule 8, the top one for you.
I will say Rule 8.4D. Conduct prejudicial to the administration of justice. Explanation. Wait a minute. Why is it explanation and not like full quote potential violations?
Because that's how the last one did, and she must have got back on ChatGPT later.
She was
and
confused.
Forgot the format.
Yeah, I was gonna say maybe. Lawyers are prohibited from engaging in conduct that is prejudicial to the administration of justice by categorically stating that my petition is founded on fabrications and likening it to past litigation in a manner that suggests a pattern of deceit on my part, girlfriend. Mr. Woodnick's comments could be interpreted as undermining the judicial process and prejudicing the court against me without due cause.
Oh my God. She's ridiculous.
Right?
Decided I'm going to paint my nails as we read this. Calming
Why?
effect. I don't know. Why not?
Your timing. ADD squirrel. I'm just going to paint my nails. I'm going to do my taxes while you're doing the stream, okay?
Why not? Why not? Let's see. Derogatory speculation and accusation. Simply said, petitioner's pregnancy was faked. The bump displayed in Judge G's courtroom was ostensibly purchased as evidence by Laura, clearly adjusting what appears to be a fake belly and guzzling a monster energy drink. Curious for someone claiming to have a high risk pregnancy. Potential violations. ARPC Rule 8.4D suggests conduct prejudicial to the administrative of justice. This rule addresses behavior that undermines the integrity of the judicial process. The statement not only questions the veracity of my medical condition in a derogatory manner, but also implies deceit in a way that could prejudice the court and public perception unjustly. Okay. Well, And listen, I
Or
can tell you
it's
this,
just
Woodnick's not the one persuading me. It's the fact that you don't know how things work. It's kind of on you. All right, you can read the next one.
ARPC Rule 4.4a. Regarding respect for the rights of third persons, it mandates that a lawyer shall not use means that have no substantial purpose other than to embarrass, delay, or burden a third person. The remarks about the pregnancy being faked and the condescending tone regarding the consumption of a Monster energy drink could be seen as intending to embarrass or demean me, which is inappropriate. It's
Yeah.
super inappropriate.
So inappropriate. I mean, she was just sipping, guzzling. What
Oh
is it?
no, she was
Clayton's
guzzling.
dick? No.
I'm sorry. I watched that. She was like slamming it back when she
Right.
was mad. She was like, "Girl, this is not an alcoholic beverage. It's a
Right? And as if like other people didn't see it with their own fucking eyes. And she's like, no, Woodnick is brainwashing everybody. Yikes.
Yeah, she's great at gaslighting people, though.
That she is. ARPC is Rule 3.4E on fairness to opposing party and counsel, which obligates lawyers to refrain from making unfounded allegations that do not have a factual basis. The assertion that the pregnancy was fake without providing concrete evidence directly undermines the principle of fairness in litigation. Think of the fairness, you guys. So many things just
Why
poor
is this
Laura
highlighted?
guys. I don't know.
Is this just so that we know this is? Wait, it says reply.
This is a whole different motion
Oh,
that she's going to talk about now, which is probably still about the same exact
yeah.
thing.
And
so.
no, it's Rule 26.
Oh, fuck.
Yeah. All right. Accusations of fabricating a pregnancy narrative. Full quote. The entire pregnancy narrative was nothing more than a fraudulent ruse to coerce respondent into dating petitioner. Clarification. She needs that clarified. I vehemently deny fabricating any pregnancy narrative. This baseless accusation is not only damaging to my reputation, but also undermines the integrity of the legal process. Oh my gosh. Violation. This allegation by the respondent's attorney could be seen as a violation of Rule 8.4C of the Arizona Rules of Professional Conduct, which prohibits conduct involving dishonesty, fraud, deceit, or misrepresentation.
It's so weird how she has 14 felony charges for like all of those things.
And isn't that how that Love Trap podcast ended? Laura has 14 felony charges. Clayton does not.
Mm-hmm. Banger of an ending. So good. Exactly. Baseless claims of coercion. Petitioner's underlying petition to establish was filed without merit and for the sole purpose of coercing Clayton into dating Laura. Potential violation. The claim that my filings were aimed at coercion is not only false, but also an affront to my character. She really doesn't know what her character is about, does she? You're not the good guy, Laura. Sorry. My actions have been driven by a pursuit of justice and truth, not by any ulterior motives as suggested.
Oh my God.
This could be seen as a violation of Rule 3.1, which requires that a lawyer shall not bring a proceeding unless there is a basis in law and fact for doing so that is not frivolous. Excuse me, frivolous.
I thought you were about to cry.
No.
I was like, girl, she's getting into it.
Accusations of using legal filings as a form of personal coercion without evidence are unusual and disparaging. She would never, you guys,
Every time she writes the pursuit of justice and truth, I keep waiting for truth, justice, and the American way. Because you know how they always say in the pursuit of truth, justice, and the American. Anyway, it's I guess me. I'm the only one that found that funny. Thanks for faking it. You should have laughed a little. You didn't. You laughed on the inside.
I did.
I'm just
kidding. My inside was going, ha! You got a bah out of me.
I'm just kidding. I'm just picking on you.
Oh, all right.
All right.
Because
I don't know. No, it was my turn. It's gonna be a Friday, y'all. Okay, throw it all out the window.
It's fine.
It's fine.
All right.
Unfounded allegations. Wait, are we on baseless claims of coercion? I don't even know where we are anymore. No.
No, you're on this one.
Proof. Yeah, unfounded allegations of misuse of judicial resources. I told y'all I was out of it. I'm like in a weird place today. Full quote, this entire action by petitioner is predicated on fraud upon the court. Potential violation. This statement, oh God, it's a pair. Okay. This statement is not only deeply insulting, but also undermines the integrity of the legal process by making unfounded accusations of fraud and fabricating evidence. It also includes a personal attack that is both disrespectful and unprofessional. Okay. Such allegations could breach Rule 3.3, which mandates candor towards the tribunal.
I like that they call the tribunal. I just want to say that. It's pretty.
Oh, yeah.
Like that word.
It's like
the tribunal.
I feel like it's like one of those Survivor. Yeah. Like you're in front of the tribunal, like you're being, it is kind of like.
Well, have you ever seen like the inside of like appellate courtrooms or even the Supreme Court courtroom? Like it's so different than like the courts we watch all day. Oh, yeah. And then it's like,
oh, I like watching the appellate courts when they go in there and have to argue and they have to do it all in like 5 minutes and then they switch over and it's just watching the judges rapid fire questions at them and they have to respond. It's super fun.
It is. It's very interesting to watch.
So anyway, where was I? Tribunals. Claiming an entire legal action is fraudulent without substantiated evidence, undermines the integrity of the judicial system, and is a serious accusation. This could also be seen as a violation of Rule 8.4c of the Arizona Rules of Professional Conduct, which prohibits conduct involving dishonesty, fraud, deceit, or misrepresentation. Furthermore, it may also violate Rule 8.4d, which prohibits conduct that is prejudicial to the administration of justice, given the disparaging and unfounded nature of the comments made.
The foreshadowing that Laura does.
Right?
It's like, oh, girl.
Like,
yikes. Okay.
I want you to remember this.
Yeah. Claims of evading discovery without merit. Petitioner continues to seek out media attention and exhausts all her procedural remedies to evade basic discovery and disclosure obligations. Potential violation. This might infringe on Rule 3.4, which involves fairness to opposing party and counsel. Suggesting evasion of discovery without proof is not only inappropriate, but it also undermines the procedural fairness of the legal process. I have been desperate to stop media attention. Girl, really, Laura? Like you literally went to everybody. And then you wrote Medium articles. Stay off the internet. Stay off the internet, Laura. Jeez. Don't sit there and say, I've been trying to stop it, even though I wrote 17 blog posts. Like, you're never going to win against the internet, okay? So just stay off of it. Which is why I filed for a protective order since Mr. Woodnick has leaked every document to the press.
Really?
But don't look at my Dropbox that I gave to all of Reddit and other and everything. It was supposed to be in private. This is provable because what has been leaked is in full color, which court documents ordered properly would not be. And they are released to a content creator who Mr. Woodnick went to dinner a few weeks ago before they were even in ECR. Dun, dun, dun. I wish they were in color, though. I mean, honestly, the grave rubbings
Wouldn't
are.
she have them in color?
Yeah,
And honestly, what colors are they actually using? I'm just curious.
I don't know. David uses all the colors, which I'm
Yeah,
not
but he's
opposed to.
like the only one I've ever seen.
Me
Where I'm
too.
like,
He likes to jazz it up a little bit, which I do appreciate.
I would use pink and put hearts at the end of it.
No, I think she's talking about like the
heart.
exhibits being in color, you
Okay.
know, like some of the text messages and stuff, which again, we live in 2026. Why not? It's not like there's not the, you can't just make them in color. So anyway,
You want to know why?
fine.
You want to know why?
Hmm.
I had to send off games to Office Depot to get printed for my grandmother's 90th birthday, and it was like $100 to print those out in color versus the 30 in black and white. That's why.
100. Wow.
Yeah.
Holy crap.
Yeah.
Okay. That's ridiculous.
That's why it's expensive for colored ink.
Well, yeah, but if you're just sending stuff like, you know, and attachments and everything, it could still be in color. I don't know. I'm for it. It makes our job easier. Please and thank you.
Do you think they send them out in attachments or they go in and get actual copies?
I don't know. I don't know. That's a good question. All right, next.
All right. Accusation of harassment through litigation. Full quote. Petitioner's behavior in this litigation is unreasonable and predicated on bad faith. Potential violation. This could potentially violate Rule 3.1 regarding bringing or defending a proceeding only on a basis that is not frivolous. Accusing someone of bad faith litigation without solid evidence can be seen as an attempt to tarnish their reputation unjustly.
In attack. Speaking of unjust character attacks, perhaps if petitioner provided the statutorily required fetal death certificate, she would look less like a crazed woman who fabricated a pregnancy. Potential violation. This personal attack could be seen as a breach of Rule 8.4D, which prohibits conduct that is prejudicial to the administration of justice. Such derogatory comments are not only inappropriate, but also demean the legal and judicial process by introducing unfounded personal attacks into legal filings. Okay, Nora. Okay, fine. She's ridiculous.
Do you think this just makes her feel better?
I think so.
Like, this is a lot of words. Like, she could be doing so many other things. Don't you have horses to feed or something?
Hi, Bacon. Hello there. Hope you're doing well. It just, it's so weird. It's so weird.
Every single, okay, where are we at? Misleading claims about legal filings. Full quote. Every single filing in this action by petitioner has been presented for an improper purpose, such as to harass, cause unnecessary delay, or needlessly increase the cost of litigation. Potential violation. This could contravene Rule 3.1, which mandates that a lawyer shall not bring or defend a proceeding unless there is a basis in law and fact for doing so that is not frivolous. Accusing all filings of being for an improper purpose without evidence is misleading and injurious. Okay.
Okay. Is that a Monster Energy drink you're pounding?
I am
cheese.
sipping it gingerly. I am nursing my
Guzzling.
energy drink, but it's not. I've only drank half of it. It's an Alani Nu cotton candy flavor, not sponsored, but I'll take a sponsorship.
Okay. Wow. Claims in legal documents are not definite defamation, even if wrong. That's true. I mean,
That's what I've been saying.
That is exactly how that goes. Bruce, maybe he actually wants to kiss you, which is why he throws sand at you at the playground. I mean, maybe, you know, but if you just want to be
Oh, wait, I thought
friends,
how
be
you know
nice.
when people like you.
That's true. I throw things at Buffy all the time. And I'm like, look, I love you.
Usually dirty looks and the occasional B word. That B.
That bitch.
If she was
No, I'm
ever
joking.
really nice to me, I would worry she didn't like me anymore.
That's not true.
I'm kidding.
I know.
Look, I didn't get to defend myself last night.
It's so funny when we do like start having like conversations like we're all so like sarcastic with one another because we've been together for so long, right? That if people came on the outside, they're probably like, "You guys are fucking assholes to one another," and we're like,
Like,
"No,
do y'all even like each other? We actually do.
this is our love language." Okay, they're actually very deep inside jokes. All right. Inappropriate speculation. Is that where I'm at? On medical evidence?
Yes.
I forgot. Okay.
Oh,
Too much is
Lord.
going on.
We have lost the plot today.
Yeah. Yes, girl. Inappropriate speculation on medical evidence. Despite her repeated assertions, positive HCG tests are not verifiable medical evidence of pregnancy. Potential violation. This statement could potentially violate Rule 8.4c by insinuating dishonesty or misrepresentation regarding medical evidence without proper basis, which is disrespectful and could mislead the tribunal. Has anybody like resent this to her now that she has 14 felony charges about all of this? Like,
Do a
oh my
Laura
God.
Owens, "This Is Your Life" stream. Remember like that old show? It's like, "This is your life," and it just goes back to like all the times you said this, all the
Yeah.
times you said this. Oh, that could be fun.
Goodness, that could be fun. I
Okay.
want to write her back now and just be like, potential violation, Laura. Have my own list of
Ubs,
breaking my rules.
right? Well, just any life's rules. Unsubstantiated claims of deceptive court behavior. Good Lord, is she just making this up? Full, I'm like, are these real? Like real things?
Who
Anyway,
knows?
full quote. Petitioner then appeared in full quote. Petitioner then appeared in court wearing an ostensible. I feel like we're repeating shit. Ostensibly fake pregnant stomach, furthering her fraudulent narrative. Potential violation. If such a claim were made without substantiation, it would constitute a violation. It's like we're rhyming. Violation, substantiation, violation, misrepresentation, all the Asians. Sorry. I said Asians, not Asians.
I was like, what did you just say? Asians.
Asians, not Asians.
It's
If
Food
such
Cog
a claim
Friday,
were
guys.
made,
We don't know
yeah,
what's
it's
happening.
Food Friday. If such a claim were made without substantiation, it would constitute a violation of Rule 8.4 for conduct involving dishonesty, fraud, deceit, or misrepresentation, given the seriousness of accusing someone of deceiving the court in such a manner. Oh, that was a lot. You got the next one? You need me to do it? Are you okay? Is someone in the house? Blink twice if you need help.
No, I will feed Tom today. So
Oh.
he was just doing something. So I was like, what are you doing? You're like, wait a second, who's there? No, it's Elbow-Fee. He's here today. All right. Groundless accusations on manipulating media. Petitioner's baseless allegations that Clayton is using the court as a publicity stunt serve no purpose other than to deflect from her own culpable actions. Okay. Potential violation. This could potentially breach Rule 8.4d by suggesting manipulation of media for personal gain without evidence, which can be seen as prejudicial to the administrative of justice. Yeah. Even though she did it several times.
Claims of unfounded litigation motives. Full quote. Petitioner's filings are predicted on bad faith and contain allegations that cannot be supported by verifiable medical evidence. Potential violation. This might violate Rule 3.1, which requires that legal proceedings have a basis in law and fact and are not frivolous. Claiming filings are based on bad faith without evidence is a grave accusation. It's a grave accusation
Okay.
that undermines the legitimacy of the legal process.
Okay. Every
How
time.
does she write this with a straight face?
Exactly. Like one of everyone's biggest complaints is how she uses and abuses the court system and the process and makes a mockery over it. And here she is constantly, like every single thing she's complained about is what she does. It's right. She thinks she decides violations. She's like, you know what? How do I get a spot on that tribunal? Just gonna do it now. Every accusation is an admission. That is very true with her. Oh my gosh. All right. Allegations of unreasonable legal conduct. Petitioner continues to file meritless motions and force Clayton back into court. Potential violation. This could infringe on Rule 3.1, which mandates that a lawyer must not make a claim unless there is a basis for doing so that is not frivolous. Alleging that all motions filed are meritless without thorough judicial review is unusual and disparaging, says the non fucking lawyer. Like, what? Really?
She's
Really?
basically a lawyer.
She's basically a lawyer. I had ChatGPT make me a certificate. So, that's basically like taking the bar. Unbelievable. Right? Minnie says, you think this story can't get any weirder, but then it says, hold my beer, like every time. Or Laura, hold my monster, please. Oh my goodness. All right. Then we get, oh my God, there's still so many. We're almost done. Why would you send all these to them? Like, was she thinking like the more that I give them, the more obvious it's going to be? Listen, guys, I did all the hard work for you. So just sign here, say yes. Thanks. I would never. Would you ever be able to send like this to like the bar? Are you crazy? She's like, well, my mommy put it up on my fridge and gave me a gold star for it. So they're really going to like it.
I got a phone call. I'll be right back. I have to take it.
Okay. All right. Nope, that's okay. Let's see. We will do that. All right. So baseless accusation of fabricating a pregnancy narrative. Petitioner expended judicial resources to fabricate a pregnancy narrative to force Clayton into a relationship with her invited media attention and is now desperately grasping at procedural straws to evade providing simple and uncontroversial disclosure like a government certificate confirming the alleged miscarriage. Clarification, this accusation is not only hurtful, but entirely baseless. I have always acted in good faith and with respect to the court's time and resources. The suggestion that I fabricated a pregnancy narrative for personal gain is offensive and without merit. She is so offended, you guys. Hello, Jupiter Jeans. Hello. Hello to you. Welcome in to whatever is happening now with Laura. Why she tells the bar how to do their job. All right, so these are about the expedited motion to continue trial and motion for additional time, but not Ginger says 39-page additional time. These are things that were filed in February. Unsubstantiated claims of extortion not only fake the pregnancy, but attempted to extort him to date her in exchange for an abortion of fictional twins. Potential violation. Such a serious accusation without evidence could breach Rule 8.4c for suggesting conduct involving dishonesty, and potentially Rule 4.1 regarding truthfulness in statements to others. Okay. Inappropriate comment on court appearance. Quote, she appeared on video in court wearing an ostensibly fake pregnant stomach. Potential violation. This could contravene Rule 8.4d, which prohibits conduct that is prejudicial to the administrative justice by making unfounded personal attacks within a legal document. Oh my God, they're not legal attacks. They are observations, girl. Oh my gosh, she's so annoying. All right, let's do some more. Derogatory speculation on medical conditions. Petitioner's HCG test proved nothing, and her reliance on them when she could provide simple and basic evidence begs many questions about her credibility and motivation. Potential violation. This speculative and demeaning comment could be seen as a violation of Rule 8.4d for conduct that is prejudicial to the administration of justice, and Rule 4.4a regarding respect for the rights of third person. An HCG test is what any doctor uses to test for pregnancy. Okay, but there's like so much more to it, Laura, and there's other things that they do to confirm. Does she know what ostensibly means? I don't think so. I don't think so. I'll tell you what, it's one of my most hated words now. I feel like this is a repeat of earlier text. Okay, I do too, but really all of this is repeat, but we only have a few more, so we'll just do it. It's fine. She would have saved her family a lot of money and litigation costs if she was a lawyer. I know. Potential violation is the same level of grounds. Objection. Grounds. Very much so. All right. Where was I? Derogatory speculation. Oh, wait. I already did that one. Unfounded allegations of court misuse. Petitioner's behavior in this litigation is unreasonable and predicted on bad faith, such that Clayton should be entitled to his reasonable attorney's fees and cost. Potential violations. Claiming bad faith litigation without substantiation, which he doesn't have, since I am ample proof of pregnancy, as even provided to you. Could violate Rule 3.1 for asserting claims without merit, and potentially Rule 8.4c for suggesting dishonest conduct. Disregard for petitioner's rights. Oh, hello, welcome back. Laura wanting to be pregnant and being pregnant are two different things. Potential violation. This statement could violate Rule 4.4a by disrespecting my dignity and personal situation, and Rule 8.4d for potentially prejudicial conduct. And lastly, thank God, defamatory statements about legal motivations. Her entire petition was predicated on either lies or delusions and mirrors prior litigation involving Miss Owens and a growing list of her victims. Potential violation. This could infringe upon Rule 8.4c by alleging dishonesty without evidence, and Rule 8.4d for conduct prejudicial to the administration of justice by making personal attacks within a legal filing. The men that he refers to as my victims are men I have orders of protection against. Oh my God, I'm so glad that is done. Is that a lawful law? Terry. Oh, that was something. Hello, Minky Moon Cat. We've missed you too. So happy you're here with us today. All right, thank God that's over and done with. Let's see. So up next here, everything, you're good to go, Buff?
Yeah, that was the vet. Penny has a lump.
Um,
The last time that happened, I lost a dog, so I'm like, I have to get her in. So, like
hopefully it's
cyst.
nothing.
I'm
Maybe
hoping
it's
it's
just
not.
a cyst or something. Zoe had some when we took her to the vet she had a UTI, but we didn't. And we were like, oh shit, she has this lump. Like, oh my gosh. And they're like, no, it's fine. It's nothing. And we're just like, oh, okay. That's good. Because we totally thought this was going to be the day.
I'm just
So hopefully
hoping.
it's,
I'm like, no, not
yeah,
my dog.
not Penny. Penny's too sweet.
That's
Oh,
my
that
baby.
was a slog. Oh my goodness. All right. Let's read these brief orders by Judge Mata. This one's based on Clayton's motion to compel, filed March 11th, 2024, and good cause appearing that it is ordered granting Clayton's motion to compel Laura. That was all about like her, that was after the deposition. So they were wanting further medical records, if I recall. And they wanted contact with, was it her lawyer with the other case, I think? Anyway, she goes on to say it is hereby ordered, compel. Oh, she's going to tell us. Maybe you just waited, Llama. You're so impatient. It is hereby ordered, compelling Laura to provide Clayton with the following disclosure. All non-privileged records and communications related to the 2014 paternity matter, including Laura and Mr. Doe, because he does not wish to have anything to do with this. So Mr. Doe it is, in California. 2, all medical records for Laura from Planned Parenthood, Mission Viejo, from or about July 7th, 2023.
Oh,
3,
y'all are so sweet.
I know, aren't they? The name and contact information for the medical abortion pill provider who informed Laura she was pregnant with male and female twins, and any and all communications between the provider regarding the same, including but not limited to any sonogram and related records provided by Laura. They're like, you're going to need all the receipts. Please and thank you. A P test is not enough, ma'am. 4, the name and contact information of the telehealth doctor Laura spoke with on the day of the miscarriage, and all communications with the provider regarding the same, including the images of the 2 stillbirth fetuses with the date clearly shown that Laura alleges she provided. And 5, the text messages between Laura and Sarah Navarro, her sister, the day of the miscarriage, where Laura sent the image of the fetuses with all pertinent metadata. So, I wonder too, like, does the court not have a choice too in having her present these? Like, do they have a legal obligation to, since, if it was a late miscarriage and you don't have death certificates, you kind of broke a law. So, like, they have to? I don't know.
I mean, I would think so.
I would think so. That could be another reason. Like, well, listen, because of what you did, we have no choice but to investigate further.
Well, yeah,
Legally
because
here.
I would
I
feel
don't know,
like that means there were babies born, and where are these babies?
right?
You know what I mean? Like, it's kind of like what Nick said was, so now we have to, maybe, are they buried? If she did give birth, where are they? Like, you have fully formed baby. I
Right.
mean, not fully, they're not fully like 40-week fetuses, but they are babies.
Yeah, exactly. And Judge Mata ordered her to have the above information no later than April 19th. It has also further ordered the request for attorney fees and costs will be joined with previous requests to be heard at the trial evidentiary hearing on June 10th, 2024. Ooh. Okay, and the other one's just the same thing. Okay, next she also goes and rules on the notice of appearance and notice of pending motion. Pursuant to rule whatever, David S. Gingras, Esquire, hereby enters appearance in this matter as counsel. Okay, yeah, that's fine. In addition, for the court's convenience, undersigned counsel wishes to inform the court he is aware a motion was filed in this matter by counsel for respondent Clayton Echard on March 25th, 2024, seeking relief based on fraud. At that time, Ms. Owens was not represented by counsel. She was pro se. Technically, if Mr. Echard's motion had been properly served, Ms. Owens' response would be due 10 business days after filing, plus 5 calendar days per Rule 4, making her response due April 15th. However, according to the motion filed by Clayton, the pleading was served by emailing a copy of Ms. Owens. Email service of motions is, of course, not valid unless the recipient consents in writing to that method of service, or if the court orders service in that matter, in which event service is complete upon transmission. Here, at the time Mr. Echard's current motion was filed, Ms. Owens was pro se, and she did not consent to receive service of pleading via email. Further, Ms. Owens does not believe the court ever issued an order permitting Mr. Echard to serve motions via email. Thus, because the certificate of service attached to Mr. Echard's motion claim service was only done via mail, the motion currently remains unserved. Oh, I bet David just has a heart on right now, like fucking yes. Now that Ms. Owens has retained counsel to appear in this matter, if Mr. Echard chooses to do so, he may serve undersigned counsel in any manner allowed under Rule 43B. Alternatively, if the court would like to issue an order authorizing electronic service, Ms. Owens would have no objection. For now, and for purposes of clarity, because Mr. Echard's motion has not been served, Ms. Owens does not intend to file a response to that motion unless and until Mr. Echard complies with the requirements of Rule 43, or until such time as the court issues an order permitting electronic service. So, this is why... Oh, this is from David. Oh, I thought this was for the judge. Oh, this is for Judge Judy. Oh, I did not make good notes for this. Oh, okay. So this is for the order of protection with John Judy. Okay, so that's not really an order at all. So that's why it sounded all in his favor. That
No,
makes
it
sense.
says pending. It's regarding a pending motion.
Yeah.
The eyeballs.
The eyeballs, guys. All right, let's get into what we're all really here for today. The freaking lunch debacle. All right. So this is what we're going to get into next. This is Woodnick's reply to the lunch. Okay. So I'm going to read this first part. And then,
No.
Buff, if you can read the second one and go potty and get more coffee, that'd be great. I'm going to read this one so I can move it along for you. Hold on, let me do this. There we go. So, respondent Clayton Echard, by and through counsel undersigned, hereby objects and responds to petitioner's motion to compel lunch and for alternative relief filed April 8th. As and for his response, Clayton states as following: maybe this was meant as a joke, but in the context of the other communications from Laura, bar complaints, more threats of bar complaints, threats of lawsuits, hinting at lawsuits against journalists and allegations of rape,
He's really, really upset about
inappropriate.
that.
Should
He's going to put that in there
It is
every time.
inappropriate. Whatever, I can never say the word. The case law, parenthetically, thank you. The case law cited by Laura is factually distinct from this matter, where Laura continues to invade compliance with basic disclosure, right? Like, girl, you don't even have your shit together. Okay. All right, you read that real quick, and I'm going to go get coffee, and I'll be right back.
Okay. To be clear, respondent does not object to the notion of lunch with Laura's counsel. However, as repeatedly expressed to Laura, Clayton will not engage in lunch without the compelled disclosure and in light of the nature of Laura's communications without a neutral third party present. As detailed in an email to Laura's counsel on April 1st, 2024. As for lunch, I enjoy food. In my 24 years of practice, I have never said no to a lunch or a beer invitation, but I am saying not now. Perhaps this will be nothing more than fodder for a future blog post, but I trust you are being sincere. Your statements and emails over the phone, on your blog, on your Twitter, etc., may have been the product of passion, but they were received as combative and unpleasant. Given your verbiage and your approach online and to my team, I think Judge Motto will side with me on any trepidation issues here. That said, I am quick to forgive. And if your email is meant to be an olive branch apology for the professional allegations and overzealous advocacy, I would certainly accept that apology. As further provided to Petitioners' Counsel on April 4th, 2024, 1. While I appreciate your right to speak on all issues, I am deeply uncomfortable with the tone you are using in emails to my office, on Twitter, and in your blog. 2. Comments like, I am the Conor McGregor of litigation, and I look forward to reading their obituaries, really invokes something extremely unpleasant. Using the term special ed in a derogatory way is also not something I am comfortable with either, as a lawyer and a parent. I have never tweeted in my life. There are certainly passionate followers of this case, and that's the end of what I have. But let me see if I can pull up the rest of that while she's gone. Let's see. And I'm
back.
She had to run.
I had to run. Oh my gosh, sorry. I was like literally all this, and I was like, "Oh, what Nick?"
I'll say I pulled it up.
What Nick? What? Oh look, Booty Hole Player's here. Yeah. Oh my gosh, Billy Eichner playing Gene. Oh, shut up. That would be amazing, wouldn't it, Booty? Yes. All right.
He is the Conor McGregor of litigation. Okay, so going back to number 3. I have never tweeted in my life. There are certainly passionate followers of this case from Bachelor Nation due to your client bringing the matter to the world's attention. That said, I was forwarded some of the postings over the past few days, as well as your recent blog posts, and I'm just not sure why you are engaging with them. We don't. I am also not certain why you are publishing court documents and your client's personal medical records contrary to court order. 1, lunch does not fix the fact that that Laura has failed to provide disclosure, notwithstanding the granted motion to compel. Look, there's my southern accent coming out. I work real hard to hide that.
I love it.
Compel. These antics have delayed the work of both medical and forensic expert reports, as the experts are waiting for the alleged twin fetus pictures, records between Laura and Sarah Navarro on the date of the alleged miscarriage, and the alleged records from the telehealth doctor that allegedly treated Laura for her alleged miscarriage.
As one does.
Purposely using all of the alleged because she said he didn't use enough alleged in motions.
Probably.
These records were specifically confirmed to be in the possession of Laura's counsel when he stated, Greg, that is not going to be a problem. You are going to love the image dates because the images are dated July 23rd, 2023. July? Petitioner testified in 2 related protective order proceedings at her deposition in March.
What? So he's saying the miscarriage was now in July?
Yeah, it seems like those dates do keep changing.
How is that helpful to your client at all? Because that's
Wow,
still
she
before
did.
she filed on August 1st, David.
She
David!
was on camera with a pregnant belly in what, wasn't that November or
Yeah.
December? Something like that?
Wow. Hi, Dana. Thank you. Wow. Okay. I love all the sass. Oh, look, there's a footnote. Let's read it.
Number 1. As detailed in an email to Laura on March 29th, 2024, giving us the picture and timestamp for our forensic technology expert, Byron Neumeister, when
That's
there is
me.
already, Neumeister?
Byron Neumeister.
I mean, it's like Brad Bloodworth.
Right.
It's really good names. When there's already admissions of records
Funny.
fraud and a trial in 2 months is also not something that requires delay. And as we said before, we will address the photo if it is complemented by the alleged verifiable metadata and medical record. Laura claims she deleted the picture from her iPhone, claimed Sarah deleted too, but also claims she sent it to the telemed provider. There should be a very clear digital footprint for Neumeister, and a picture is not going to cut it in light of the history and her testimony. We are awaiting the original sonogram she claims she got anonymously from PPH, which has affirmed it does not offer anonymous appointments, and that has an easily accessible patient portal. This was the sonogram she admitted she doctored, and that is the core of our motion for relief under the OOP cause number. 2, there is a lot of footnotes. When you speak with redacted and redacted, they will confirm the fabricated document and fake pregnancy allegations were happening back in 2014.
Thank you, Amos, for gifting 10 memberships. Thank you. Congrats to all the new members. There's lots of member-only content in our member section, including other shows like Llama Learns About, where we learn about ridiculous things, as well as TMI and Coffee with me and Terry. Lots of good stuff over there. So congratulations. And you guys get to be a part of our members appreciation stream at the end of the month, where we give away prizes with a spinny wheel. Oh, I just painted my nail, and I think I got nail polish on my lip.
It's
Yeah,
Friday.
I definitely did. It's fine. All right. We're fine. All right. Am I scrolling down? Yes?
No.
Oh, sorry.
I'm not finished with that paragraph. And since you saw she blamed Greg Gillespie for the other ultrasounds that came from her email address and phone number and emails and texts, as will be verified by Neumeister, she should be reminded that she did not even know Greg existed back in 2014 when she first claimed to be fake pregnant by blank at the record, and the records were faked.
Mm-hmm. Goes all the way back, and the plot thickens. Not her first time. All right, let's pick up.
So that was the footnote. So the ending of the last sentence was petitioner testified in 2 related protective order proceedings at her deposition in March and made statements before this court that grossly differ on the timeline for the alleged miscarriage, also known as perjury.
Oh.
Okay, that was footnote 2. Perhaps in addition to trying to cajole a trial continuance, the missing disclosure has not been provided because it contains more fabricated records. Instead of acknowledging that she lied to this court, petitioner has ostensibly dialed up her Photoshop skills. She insisted on deposing Echard in February. It's video recorded, and allowed her series of since withdrawn attorneys, Bonnie Platter, Alexis Linval, and Corey Keith, to unwittingly use a sonographic exhibit that she since has admitted to doctoring.
Mm-hmm. Not great.
This is the same fake sonogram she flaunted, claiming she was pregnant with Echard's twins after showing up to court before Judges Duty and Judge G. I'm not even going to try and say that. With an ostensibly fake pregnant stomach, claiming she was 100% pregnant and due with twins on February 14th, 2024. This is not just a faked sonogram that was used in court proceedings, but petitioner testified in the collateral protective order proceedings that her OBGYNs were Dr. McCool and that she was seen last Friday by Dr. Higley. There are no records that support these statements by petitioner, and the provider's absence of records confirmed they never treated petitioner for pregnancy.
What? Shocking.
Nobody is shocked at this time. Now, contrary to the confounding responses to this court's direct questions at the last status conference and her own medical records, her public postings seem to range to claiming her alleged miscarriage either took place in July or even as late as November 2023.
Who knew?
See
Who
email
knows?
from petitioner's counsel dated April 8th, Exhibit 1.
Because that's how that whole process works.
Right?
Was that August, September, October, and 3.5 months? You're like, I don't know. Sometime happened in between there. I don't know.
I don't know. I don't know what happened. I think you'd know.
I think you would fucking know. I know you know. Oh boy.
So, 2, it says petitioner also presented evidence in these proceedings that include alleged videos of her pregnant stomach and statements by her neurologists that she looked 21 weeks pregnant. If Laura is now claiming she miscarried in July, she would not have a visibly growing pregnant stomach that looked 21 weeks.
Yeah. Because that's not how it works. That's not how it works. Oh boy. Okay.
Grave rubbings. While Laura appears to have recently toned down her social media posts, her newest counsel has backfilled that void with persistent Twitter and blog posts and outlines his theory of the case, including his anticipated motions and more. See generally postings by petitioner's counsel Exhibit 2. A sample of these postings below. David Gingras, whatever. Don't like my bio? Ask for details. I am the Conor McGregor of litigation. Done tons, big, huge, of family law cases. I don't list those because they are boring. FYI, Clayton's lawyer has handled 2 federal cases. High-profile cases go to federal court. Me, 79 federal cases and counting.
What a humble brag. He's so humble, that David.
He's
Isn't
so
he?
cool.
Oh my gosh.
And then my favorite post. Fuck these sick, selfish, lying assholes. Should I clarify how I feel? These vile scum. I mean, people are not helping anything. They are human cockroaches spreading the feces on the floor and then spinning the facts to make them more dramatic than they really are, in the hopes that they will drive traffic and increase revenue for their sad, pathetic lives. One day, these trash, I think they were talking to us. We're driving the traffic.
Together. It's all of us. We're all the sick, selfish, lying assholes.
One day, these trash humans will wake up and realize that lying for money is not a good way to live. Or maybe they will never see their sins. Either way, I look forward to reading their obituaries briefly before throwing them in the trash where they belong.
A dick, David.
You're dick, David.
This
Like
is
a big dirty raccoon, David.
Big dirty raccoon, David. That's what you are.
gross.
Okay.
She claims she has the bulk of the requested disclosure in her possession. Contrary to her testimony and statements to this court through her parade of prior attorneys, Laura has stated several times that she has the requested information. And she...
Wrong scroll.
Cliffhanger.
There we go. Dun, dun, dun.
I like the word ostensibly.
I'm so fucking tired of that word.
Really, I'm just gonna figure out how to work it into my everyday
You should,
like
yes.
conversations. Now ostensibly claims to have miscarried in July, specifically through I don't know what the last word underneath the llama is.
Oh, I'm sorry.
It's okay.
There we go.
Through counsel.
It's
Okay. Stated in emails that he had the photos of the fetuses, the contact information for the telehealth provider, and the communications between the petitioner, Laura, and her sister, all of which is requested in respondent's motion to compel. See generally Exhibit 1.
Okay.
Then there's a bunch of, so go down just a little bit because
Oops,
it's
sorry.
hidden behind the llama.
The llama.
It's
Sure,
always in the way.
Hi,
Gosh, that
Ashley.
llama. March 27th, 24 at 9:53 a.m. Let me speak with Laura about the request for the photo of the sacks. Hate that word.
Oh,
She told me she had this photo available. And if she does, then I'll immediately provide it to you today. Same with the name of the telehealth provider. ... emphasis added. March 27th, 2024 at 1:54 p.m. Having said all that, I just got off the phone with Laura and she is sending me the sack photo and the name of the telehealth person. Emphasis
right.
added.
Okay.
March 28, 24 at 5:20 p.m. As promised, I have talked to Laura about the fetal sac photos and she has produced copies of those photos to me. I have them in my possession right now. I am
Oh,
prepared to disclose these to you, along with the additional information. Laura found additional information showing a consult with a healthcare provider at the time the fetal sacs were discharged, or whatever you call it. Emphasis added.
oh my goodness.
On April 8th, 2024 at 3:07 p.m. As I mentioned, wait, is this after? How?
This is a whole how many days after?
No, it's it's like a whole month. The other one was March, and this is April. Okay. As I mentioned before, I have the photo. So it's been a whole like 2 weeks. You still haven't sent them?
Exactly. Okay, buddy.
As I mentioned, because my next thing was like, you sent them. Like, I have them. Send.
Right. I mean, especially with a guy like this. Oh man, if he had something, bet your ass he'd fucking show the whole world. Be like, look, motherfuckers. All right, you dumb idiots. I told you I was right and you are all stupid.
Right?
We'd love that.
Okay.
Immediately.
As I mentioned before, I have the photos you want to see. I understand you want to give them to your experts. Greg, that is not going to be a problem. You're going to love the image dates because the images are dated July 23, 2023.
He's not wrong. He's not wrong. He is going to love that day because that day is even worse for your client.
Right.
It's even worse.
But I'm going to love it, but not for the reasons you think I am. I also have the text messages between Laura and her sister, dated July 23rd, 2023. I do have some telehealth info showing Laura seeking medical advice on July 23rd, 2023. I don't think that is helpful to either party, but it is something I'm willing to disclose. Underlines an original, emphasis added. Now, if it's been like a week, you already told him this. What are you doing?
Right. And why would it not be helpful to either parties that she saw somebody on the 23rd, the day you're saying she has a miscarriage? Like, I don't think it's really that relevant. No, that's literally like the most important thing right now. Like, what? This fucking guy.
It would be helpful for, I mean, I guess it wouldn't, but like, I'm like you. If you have the thing you said you had, or at least what you thought was the proof, I don't know how you wouldn't be putting it on a flagpole for everybody to see.
Exactly.
The streets.
Exactly.
I don't know.
He's hyping it up too much.
No.
Hyping it up too much. That seems very suspicious.
Everybody else is dramatic.
Oh, Jupiter's birthday is July 23rd. I love that.
Yay. I'm July the 10th. So
It all just blends in together. We're just all together all day, every day. Sometimes I get sad when there's nothing going on where we can all be together, and I'm like, where am I going to
I'm
hang
so
out with all my new cult
somebody
friends?
talk to me. Instead of just simply complying with Rule 49 and disclosing the information, he acknowledges having counsel bombards respondent's attorney and his attorney's office. Huh. Not you, David.
I'm
You
telling
wouldn't do
David,
that.
never. Okay.
Okay, so there's a little footnote here. It says, notably, if the photos were from July 23rd, as current counsel is now claiming but not disclosing, then every filing after that day is per se a violation of Rule 26, and the testimony at the deposition and the protective order proceedings were all perjurous.
Yeah, David. This is not good. This is not good for you, David.
It's
But he's
definitely not
just
good for
learning, guys.
Laura.
He's just learning.
He just got here. He's new.
Thank you. He just got here. He doesn't know, guys. It's fine.
Staff with communications, comments about personal sanctions against attorneys, and suggestions that the state bar needs to be involved. Petitioner, having already filed 2 complaints, dismissed, and at least 2 others against her prior attorneys also dismissed, and so on.
Yes, Ivy, this is the lunch Woodnick's response to the lunch
To
Rule
the
26
lunch.
drink.
Yeah, we're gonna have no. Everybody would be drunk in like the first hour of the stream. Okay, so April 3rd, 2024 at 11:20 a.m. Jesus, man, seriously? I mean, seriously? Does Clayton mean that much to you? So look, I guess what is going to happen next is you can submit your proposed order on the MTC to the court. I guess that's the motion to compel. I will respond and object to the order, and I will probably have to file a motion asking for relief on the basis of fraud by you. This stuff is going to be messy, like really messy. If you won't agree to do something remedial, I need to be clear about what happens next. I am going to file something explaining this crap to the judge, and I'm going to ask her to make a referral to the state bar, and that applies to both you and Isabel. Isabel now knows that you have lied to the court multiple times. She cannot sit back and allow this to continue. I don't care if she's new, and I don't care if she hasn't signed any pleadings. That is irrelevant. Isabel cannot stick her head in the sand. She has an absolute duty under ER 8.3 to report professional misconduct, as do I. She also has an absolute duty under ER 8.4A not to help you violate the rules. If Isabel sits back and lets this go further off the rails without taking appropriate remedial steps, she is putting her own license in peril.
What? I can't wait to read this bucket. What is this in reference to? Why is he all worked up? Whoa. Okay. This stuff is going to be messy. Like, really. Sir, you are messy.
Sir, I want the whole context of all of these emails. We need to make sure we're reading them in order if they're like listed opposite.
yeah.
I want the full, like having pieces in the motion is kind of nice, but I want the whole thing.
While you're reading that, I'll make sure. I'll see which order they go, because you're right.
I mean, I don't know if they're even in there. I haven't looked. I haven't read this at all.
We got a lot of emails in the next exhibit. Yeah, so
I've read enough to get the little headline on the thumbnail. Maybe this was meant as a joke, and that was like, that sounds good. Okay, April 4th, 2024. As a compromise, I offered this proposal. Don't apply for fees right now. In return for you not seeking fees right now, I will agree not to bring a motion asking for relief from the motion to compel order on this basis of fraud. Like I said, I'm not happy about what I have recently learned, but if we can avoid fighting over that new issue now, it would be helpful for both sides. Whew, he comes out hot.
By the way, these are not even close to being in the right order, so we're just kind of...
that does not surprise me.
Nope. That's okay. But it's a lot, I'll tell you that. We're going to have fun.
Oh, goody.
We're going to have a lot of fun.
Oh, goody. 3. Petitioner's motion is also misleading. The parties are communicating over email, and Laura is responding where appropriate. Laura's motion is also misleading. The parties are communicating over email, and Clayton is responding where appropriate. Undersigned has no ethical or legal obligation to expose himself to unnecessary criticism that is not conducive to resolution. While Laura's counsel did eventually apologize for his toxic comments, the online activity continues and the toothpaste is out of the tube.
Uh-oh.
Can you scroll up just a bit?
Yes, ma'am. Yes, ma'am. Oh my goodness.
It's getting a little bit sassy.
It is.
Undersigned
Yes.
counsel realizes that filing this objection and bringing the above mentioned to the attention of the court will likely escalate Laura's tactics, but believes it is relevant for the court to have all the information when considering Laura's motion to compel lunch and alternative relief.
Remember that in David's motion, he was like, none of that actually matters. Like what we were talking about, Your Honor. Like he's going to say some stuff, but like don't listen to it because it's not relevant of why we're not talking.
That's
but I wanna
right,
have
he
lunch
did.
with him. He's like that part's not important.
Is Laura paying? That's the question I would have. This is not a complicated case, contrary to what Laura promotes. Trial already continued once due to the same lack of disclosure is in June, and Clayton is prepared to proceed and argue appropriate inferences consistent with the data set and lack thereof, and the court can enter relief as deemed appropriate. Clayton is entitled to his reasonable attorney's costs and fees responding to this motion pursuant to ARS 25-324. Laura has been forced to incur. Petitioner. Wait, I don't know.
Petitioner is Laura.
Is he? Yeah, Laura has been forced to incur significant fees due to respondents' continued efforts. No, that's what I'm saying. It's backwards.
Yeah,
they have them backwards. Okay, so Clayton has been forced to incur significant fees due to Laura's continued efforts to avoid resolving her perjurious statements in these proceedings that have affected at least 3 cases in Arizona, not including those involving other presumable victims in Arizona, 2 and 1 in California. Quite simply, there is nothing to be resolved without the disclosure. Clayton has already spent significant time since at least October 23 attempting to gain access to. I think they have things mixed up. It just sounds weird.
Yeah.
Or maybe it's just me. Attempting to gain access to, which have repeatedly been met with Laura's overt efforts to avoid the same. No, maybe they had that right. Now I was confused. Likewise, intimidation does not resolve this. Attorney's fees and accountability do. Wherefore, the respondent respectfully asks the court to deny Laura's motion for lunch, grant Clayton leave to file a China doll affidavit for his reasonable attorney's fees, and enter appropriate sanctions and other relief as the court deems proper.
Mm-hmm. Well, that was a little sassy. I like it.
I
Let's get
loved
into the
it.
emails. Yikes. Even those little glimpses into what the emails hold. Yikes.
Oh my gosh. He was he was unhinged.
Mm-hmm.
Like he was like threatening Isabel. Like she's like, hi, I'm just over here. Like what? Why are you bringing me into it?
Right. All right. So who do you wanna be Woodnick and I'll be David?
Whatever you want to do.
All right. You were very good with Woodnick being like, what in the fuck? All right. So this is an email from Greg to David. These are all out of order, so we're just gonna have to deal with it. Friday, March 29th, 9:31 a.m. Because they don't do anything in order, which is very annoying. Very annoying. All right. So this is from Woodnick to David.
Okay.
Oops.
David, I did hear Lexi moved to Texas with her husband, also a lawyer and a great guy, who clerked for me moons ago. Billy T will know what is going on at that office if you're getting a bounce back from Lexi's email address. I can't imagine that she was not given her file Wait, she was not given her file, given Laura filed a bar complaint against her. It was investigated and dismissed. She also has recently filed for a protective order. I was endorsed by the bar because I got a complaint at the same time as Lexi. 2. Corey went out on his own during his short tenure. He responds quickly, but his paralegal is wonderful and super on top of things. So you might want to copy her if you are emailing. Is Isabel Sissel, and then her email. Don't email them. I'm glad you were able to get a hold of him. We object to any extension. It is not you. It's me. It's not you. It's me.
It's not you.
It's not. It's like he's trying to play fair. It seems like it's a pretty even-tempered one. I imagine these escalate with time. You are just the upteenth attorney and the upteenth who thinks they can get this resolved only to be fired or need to withdraw for ethical reasons.
Yikes.
I appreciate and am really respecting your cautious approach to not step in dog shit.
I love it. Okay.
I do too. But disclosing the date of the alleged miscarriage is not something that requires Laura getting a continuance, and we will object to the same. Giving us the picture and timestamp for our forensic technology expert, Byron Neumeister, when there is already admissions of records fraud and a trial in 2 months is also not something that requires delay. And as we said before, we will address the photo if it is complemented by the alleged verifiable metadata and medical record. Laura claims she deleted the picture from her iPhone, claims Sarah deleted too, but also claims she sent it to the telemed provider. There should be a very clear digital footprint for Neumeister, and a picture of a picture is not going to cut it in light of the history and her testimony. We also are aware the original sonogram she claims she got anonymously from Planned Parenthood, which has affirmed it does not offer anonymous appointments and that it has an easily accessible patient portal. This was a sonogram she admitted she doctored, and that that is the core of our motion for relief under the OOP case number 4. There is already an order about the medical records. We have been through this with her failed motions and whatnot. We need that picture to give to Doctors Dean and Justia Line. Does Justicia Line? Anyway, again, we are not interested in a picture of a picture. That is where the arts and crafts issue comes in. And notwithstanding, Laura invoked Rule 2. When you speak with blank and blank, they will confirm that fabricated documents and fake pregnancy allegations were happening back in 2014. I guess I can guess who those names are. And since you saw she blamed Greg Gillespie for the other ultrasounds, why would you delete them there and then not there? But I don't know.
Oh, no. The other names were the guy and the lawyer from the case before Mike.
Oh, okay.
Yeah.
So then I didn't guess who that was.
No, yeah.
And since you saw she blamed Greg Gillespie for the other ultrasounds that came from her email address and phone number and emails and texts, as well as will be verified by Neumeister, she should be reminded that she did not even know Greg existed back in 2014 when she first claimed to be fake pregnant by Matt.
Dude. My dude. And the records.
And the records were faked. Our paralegal, Maribeth, will be sending you the deposition exhibits under separate cover. Again, this has nothing to do with you. It's not me, it's you. All right, it's not me, it's not you, it's me. Again, no, it's not me, it's you, David. It's all you.
You, David.
Again, this has nothing to do with you. We have been involved in litigation with Laura since 2021, and is there something behind Llama?
That's the word.
And this case, collateral proceedings since October, and her claims and delay tactics are exhausting. I agree.
Signed GW.
Signed
He doesn't even put Greg anymore. He's like, All right. So the next one is from David to Greg, Thursday, March 28th. So this is the day before. So this is what Greg is responding to from David. Greg and Isabel. Quick follow up on a few things. One, per the attached email, I just learned that Laura's first attorney, Alexis Linval, is no longer with the modern law firm. Unfortunately, her AZ bar record still shows she's her working there, but apparently her LinkedIn has been updated to show that she has left Arizona and moved to Texas. Yuck. What? So weird. Why would you say any of that like that? Based on this, it sounds like getting a copy of the file from Alexis may be a challenge. As you'll note, her firm claims that a copy of the file was given to Laura, but Laura says this isn't true. And why would she lie about it, you guys? Why would she do that? She would never do that. In any case, that issue will need to be resolved one way or another. 2, after not hearing back from Corey, I gave him a call this afternoon, and fortunately, I was able to reach him. I didn't realize he had also changed firms, apparently in the middle of the case, per a notice he filed. Corey said he's going to need more time to finish gathering Laura's file, but he promised to get this to me ASAP. Like, how big is this file anyway? Like, okay. 3, since I don't have the information I need yet, I'm going to file a motion asking the court for more time to respond to the motion to compel. And he does. He writes 39 pages for that. If you want to let me know your position, I'm happy to include a line that says I've consulted with you and you do or do not oppose the request. It's so clearly appropriate to ask for more time. And it is, David. That's fine. You just got here. I know the court is going to grant the request, whether it's opposed or not, but just let me know your position so I can include that in the motion. Look at him just being a great guy. 4, as promised, I have talked to Laura about the fetal sac photos, and she has produced copies of those photos to me. I have them in my possession right now. I am prepared to disclose these to you, along with some additional information. Laura found additional information showing a consult with a healthcare provider at the time the fetal sacs were discharged, or whatever you call it. David.
Discharged.
But Laura is concerned about these photos being publicly released, and she's asked me to request that you agree to a protective order as to them. Look at her being concerned about her dead babies, but not the other ones that she stole ultrasounds from. Okay. Note, I have spent several hours today reading through all the pleadings on the docket, and I see there was a prior motion for a protective order which you opposed and which the court denied. Obviously, I wasn't involved with all that, but my guess is that the motion was denied because it was simply too broad or non-specific. Here, I am just asking for you to agree not to publicly disclose photos showing bloody tissue, at least until trial. This is a very narrow request, so I don't think there's a good reason to oppose it. Nevertheless, please let me know your position. 5, I finished reading Laura's entire depo, which was extremely helpful. You don't say. You don't say, David. But the copy of the transcript provided by Isabel did not include any of the exhibits. What? I can see on the record that Corey ordered a complete transcript, so maybe I'll get those once he hands over the file. But in the meantime, if you have a copy of the exhibits, hopefully numbered according to the transcript, that would be super helpful. And here's a thanks, and more updates will follow shortly, I'm sure. Well, I'm sure you are sure, David. So here's Lexi Linval's leaked ends showing she's in Texas. Who fucking cares, David? Who cares, David? All right, so the next one is also from David. Thursday, March 28th.
And
To
Alexis.
Corey, Alexis, and Greg.
He's going to harass them too.
Corey and Alexis. I love that it's Alexis and his name is David. David. Corey and Alexis, it's been over 24 hours and I have not received a response from either of you to my message below. I'm sorry to be a pest, but as you may know, Mr. Echard's counsel has filed a motion to compel in which he argues that discovery was not previously provided by Laura. He also claims that he tried to meet and confer with current counsel, which I think was a reference to Corey, but that he did not receive any response to those efforts. The response to the MTC is currently due Monday, April 1st, and in order to fully respond to that motion, I need to receive copies of Laura's files because I have not received them from you. I'm probably going to file a request for an extension of time, but that still does not make any of this any less urgent. Please respond to me by the close of business day, or I'm having the babies, to at least acknowledge receipt of this email, because I don't know how to put email read receipts like Laura does. I should probably ask her about that. And please let me know when I can expect to receive the case files from you. I will also follow up by phone with both of you later today. Thank you, David. Oh, God. He's so annoying. He's just as
He
annoying as her.
didn't say all the best. I'm kind of sad.
I'm sad too. Jeez, David. Oh my gosh. I didn't realize I was going to be reading so much, but okay. So this is the day before he sent that one that we just read to Corey and Alexis. This one too is to Corey and Alexis. Corey and Alexis, I've just been retained to represent Laura Owens in the paternity matter involving Clayton Echard. They're probably like, sucker. I am CCing Mr. Echard's counsel on this message just to keep Greg and Isabel informed in my progress. A confirmed copy of my notice of appearance is attached because I have only been involved in this matter for a few days. I'm still getting caught up. And as part of that effort, I need to request copies of Laura's file from both of your offices. I have access to all of the pleadings on ECR, so please do not send any of those. Instead, I'm mainly looking for two things: copies of case-related correspondence and copies of any Rule 49 disclosure documents, which presumably would have been sent to Mr. Echard's counsel and thus may already be covered by the first part of my request. It's like they sent stuff to David, Woodnick and them, and Woodnick just refuses to believe that that's all there is. That's how I feel about it. Well, because he wants all
Woodnick?
the case-related, that Woodnick like shared what they have with David.
Oh, yeah.
You know, and David is just like, it can't be, this can't be it. There's no way. I don't believe you. That's how I feel about it. I don't know if that's true, but
It's because your client didn't want to hand anything over.
right. Now, ideally, if you use Outlook, I prefer just to have case-related emails exported to a single PTS file. If you're not using Outlook, I'll just take the emails in whatever form is easiest for you to produce. If you need me to send you a link to an online folder because the files are too large to send, please let me know and I'll send you a link privately. Obviously, Greg and Isabel shouldn't receive copies of any privileged communications. That's right, Wink. Shut up, David. Exactly. Why wouldn't he have it all? Because Laura said, no, that's not it. And he believes her. No, David. I know it all sounds weird, but like, I'm telling you, there's more, David. My past attorneys were so mean and trying to embarrass me, but there is more. I promise. I promise, David. Right?
She's not
She
getting
lied.
everything. And it's making me look bad.
I love the way Llama says David. David, all the time. Love it. Okay, so that was that. Oh my God, here's another one from David. This one is this before or after? Let's see.
You picked the wordiest man to read.
I did. I'm an idiot. This was at 12:24 p.m. So this one is after. No, this is 12:37. This is before. Greg, let me speak to Laura about the request for the photo of the sex. I hate that word. She told me she had this photo available, and if she does, then I'll immediately provide it to you today. Same with the name of the telehealth provider. And just to be clear, while I don't mind expediting these issues, it's obviously needed. I don't really intend to commit to a quid pro quo as far as getting you to agree to an extension of time to respond to the motion. I don't think that's appropriate at this stage. Oh, wow. Thank you, Winks and
Hey.
Wilks, for sending or for gifting 50 memberships. That's so
Oh
nice
my
of
gosh.
you. Thank you. Congrats to all new members. Oh my goodness. You guys are going to have so much to watch. Thank you so much, babe, for your support. That's so nice.
Aw.
Thank you. Oh, happy Friday. Thank you. Oh man. Gosh. Okay. Holy Jupiter.
I
Shit.
know. I know. It
I
caught me
know,
off
right?
guard.
Y'all better have your gifts turned on your profile so you all can be green too. Oh my gosh, that's amazing. Thank you.
I
So
love that.
David's saying, I'm not gonna commit to the quid pro quo right now. I'm not gonna do that, but I'm also going to probably call you out for not doing it with me anyway. Watch, I bet it happens. If it was absolutely essential, I could easily respond to the motion by Monday. Oh, but that isn't the point. So he could respond. He didn't even need to ask for extra time, but you know what? It's fine. Don't worry about that. The point is that I don't want to file something that isn't helpful to the court because I haven't had enough time to gather information needed to provide a comprehensive explanation of our position. He doesn't want to file something that's not helpful. Okay.
Okay.
All right, sure. Oh, love
Yeah.
that. You guys are amazing. Yeah, you have to turn them on. I think it's if you click the join button on our page, there's going to be like 3 dots there and you click those and then there's like the gift option and you can do it that way. But then also if you have like a branded account, which I don't know what that means, that can be a reason too because YouTube is stupid. And Wings is amazing.
She is.
She is.
Can confirm.
Can confirm. We know. Let's see. Also, I don't think, based on what I've seen so far, that a sufficient good faith pre-filing effort was made to resolve the discovery disputes, which may not even be real disputes. Oh, there we go, Nightbot. Thanks, Amos. That is probably the fault of Laura's prior counsel, assuming they didn't respond to you. But since I don't even have Laura's files yet, I'm not in a position to know if that's the case. As you saw via separate email a few minutes ago. Okay. I just reached out to Laura's prior counsel to ask for her file. Hopefully, I will have this information later today. For now, as it relates to the motion to compel, I'm just not in a position to even explain my side to the judge unless and until we go through the process of talking about these issues in detail, which is what I'm trying to do now. So here's my plan. I don't want to make a deal regarding the motion. Instead, I'm going to do everything I can over the next few days to dig into the issues raised by your motion and either resolve them by giving you what you're asking for or by investigating the issue sufficiently so that I can explain our position to the judge. I don't accept half-assed, incomplete stories, so I have no intention of giving one to the judge. Sir, you say all the time, we'll save that story for another day. All right? How many stories have we been promised by him? He even wrote it in the court motion one. In that motion, he tells the judge, well, that's a story for another day, judge. Oh my gosh. Wow.
Yeah. Oh my gosh.
Okay, sir. Since the current response date is Monday, my plan is to either fully resolve the issues before then, or if that isn't possible, at least I will be in a position to explain to the judge what's going on, as if she's brand fucking new to this too. and why the motion is either moot, without merit, or just ultimately premature because there wasn't enough effort made to resolve the issues. I can't tell the judge what our side is until I complete my investigation into the issues. But he's already pointed out yours is all wrong. I know I haven't investigated, but it's wrong. Yours is wrong
I
because you're a
just got
fucking
here,
idiot.
but you're all dumb, and I'll fix this. I can fix her.
Oh my God, he's so like that, right? Like, yeah, I got it. I can do this. In other words, let's just keep pushing forward from now and then let's see where things stand on Monday. We've already read like $600 worth of emails in the few that we've read already. Oh my God, okay. All right, finally, one with Greg.
You get a break.
Yes, I know. I gotta go potty. Like, oh no. Okay.
David, we really appreciate your willingness to take this case so far along into litigation. I appreciate you wanting to focus on a resolution. Having spent Clayton's legal fees, having this exact conversation with a parade of prior attorneys with similar good intentions, please understand we are a bit jaded. Multiple prior lawyers unwittingly presented court records to courts that were fabricated by Laura. Those records not only were medical, but also included fake letters from law firms. It is really unbelievable. Put bluntly, Laura has misused court processes in multiple states to perpetuate the most bizarre of cons for relationships. She is either seriously mentally ill or diabolical. I can't believe he said that. But I mean, I don't disagree because that's kind of the consensus I've come to is that she's either seriously mentally ill, my opinion, Laura, or she's just diabolical. 4 very established men have documented her fake pregnancies, demanding relationship contracts for abortions and fabricating medical records. You might want to call blank attorney in California. While the media seems to think my office orchestrated figuring out this pattern of fraud, it was actually redacted who first dealt with Laura's fake pregnancies and suicide threats back in 2014. We are looking for a finding that the filing and subsequent filings were malignant per Rule 26, etc. We get that Laura may be judgment proof as far as prior attorneys have discussed, but of course that is not the legal standard, and Clayton's ability to collect a fees judgment is not really our focus. Clayton is entitled to the court findings that Judge Mata will make in 3 matters. 2 things can be true at the same time. I'm leaning on she's both. I say that all the time, Sammy. You know. Anyways, so now I lost my spot. Clayton is entitled to the court findings that Judge Mata will make in 3 matters now in her lap: paternity, order of protection, and injunction against harassment. The value of that judgment may only be on paper, but TEDx Laura, Medium Laura, and Reddit Laura need to be recategorized as fiction because she will, the minute you are out of the case or sued her as she did with Corey, start spinning more yarn, emailing the media, and sabotaging more of Clayton's professional endorsements with her nonsense. Note, there is currently an investigation regarding Laura's pretending to be a Black Howard University reporter who does not exist, and distributing an article in the middle of this case, attempting to cancel Clayton, claiming he was involved with the use of the N-word. I think we've read this email before.
I think so too, but I love it. I love how Windicka's just like, listen here, let me tell you about this bitch, okay?
Mentally ill or diabolical.
Which is so accurate and true.
I know. I was like, yikes. Contrary to Laura's beliefs, we do not control the media circus she started. But if Laura wants the reporters to run out of material, she needs to stop feeding it to them.
Facts.
She should go whatever DBT. Oh, yeah, I remember this one. She needs to go to whatever DBT inpatient program can help her stop living in a perpetual con. She needs to admit the fraud, dismiss the protective orders against Clayton, Michael, and Greg, and have you help her write a public apology. I am not a cast member, but she would also do herself a world of favor if she included in her apology the malignant rape allegation about both Greg Gillespie and myself that she made to Judge Bacchus in her public apology. That said, we know the Title 25 court only can do so much here, and the paragraph above is pie in the sky. Still, Clayton is exhausted emotionally and financially, but he is fully committed to this litigation until we get a judgment that he can show the world. So, motion to compel. We agree. There is an obligation to avoid discovery issues. We did that long before you were on board, and filing the motion to compel was already a last resort. Clayton is not willing to withdraw it at this time because we are 10 months in and Laura faked medical records and we have a trial date. We also have our experts who need whatever other records Laura claims she has, but with proper, verifiable chain of custody given her propensity to cut and paste. We would consider a brief extension for a response as a professional courtesy to you, as this is not your fault, but with some contingencies. Any extension would require Laura to immediately provide the picture she now suddenly claims she has of the fetuses that she testified she deleted and did not have her iPhone anymore, and that her sister deleted them. That information should be provided today from you. It will be time date stamped and will put an end to the great mystery of when the alleged miscarriages happened. Remember, she stated in court that she did not know. She stated in deposition the same. So how wonderful it will be to know by the date stamp on the image that will also be in her medical records from the telehealth doctor she sent the image to.
It's not hard.
If it exists, but she's got to hurry up and make one.
Mm-hmm.
We are eager to read the records from the doctor who told her not to worry about miscarrying 20-week twin fetuses, which would never happen. They would have just said, go to the hospital.
Yes.
Which would actually be fetal death, warranting a death certificate under law. She must also immediately provide the name of the telehealth provider so we can obtain the records directly from them, which should include the photo per her sworn testimony. Laura knows there are no medical records that support her fake pregnancy narrative, as confirmed by the 7+ providers who have no records of ever seeing her, notwithstanding her deposition and testimony and 2 protective order proceedings. I trust you have reviewed the records from Planned Parenthood, Dr. McCool's office, and Dr. Higley, where they confirmed that your client was never a patient there. We will issue another HIPAA records request for the Banner records, but expect them to similarly be lacking in evidentiary value. We appreciate you have a lot to sift through, and you getting a brief extension is reasonable, but we need the telemed provider and the picture that has now magically appeared, contrary to her testimony, today. Once we receive these, we can discuss what length of an extension is reasonable and further discuss resolution options. Again, please do not take our instance here personally. You may withdraw or be fired before the ink dries here, and we need to move this forward. If it resolves sooner, that'd be wonderful and welcomed. Greg and Isabel.
Now that we've read David's stuff, do you think that like he read this and because he can never lose face, that's why he became very aggressive? Like he doesn't want to admit that he was immediately out the gate conned by Laura, because I kind of feel like that, like, oh, I can't admit that I'm fucking stupid and fell for her bullshit, so I'm just gonna like quadruple down.
Yeah, I feel like sometimes people don't like to admit when they've been conned. Like it's harder for people to admit that it is for them to be like, yeah, I was duped. And people will double down on that.
That's very common. I mean, that's why scams are as lucrative as they are, right? Nobody wants to believe that, and that's pretty understandable. But
Well, I mean, and that happens when people follow really bad people too. They don't want to admit that they
it's
followed
true.
the wrong person.
It's
Like,
true.
that happens all the time. Like, they're like, oh, yeah, I bought everything that they said. But, like, you know, they don't want to say that, yeah, they kind of suck. They just keep
Yeah,
following them.
that's true. See it every day, all the time. So the next email is from David. Wednesday, March
David.
27th. Oh, this is in the morning at 9:50. See, they're not in order. This is so stupid. Oh, wait, no. That must have been their reply to that one. Okay, I got it here. All right, so this one, the one we're actually going to read, David, we already read this one. See, he talks immediately about Texas yuck.
Yeah.
What, Nick? What is this bullshit? Why is it the same thing 2 times in a row? Okay. So this is
This is another Greg email?
yes.
Because it looks like it's to David.
Yes.
I guess I'm going to get my word count in for today.
Right.
David, I appreciate that your effort to excise Laura from this mess she caused, but we strongly disagree with your analysis on Rule 26, which is legally distinct from Rule 11 in several important ways. If Laura thinks this will stop her exposure to sanctions, then we welcome your motion to strike and will respond accordingly. That said, I am more than happy to coordinate a meet and confer with you both, but that will have to be tomorrow, as I'm in mediation with Jared Sandler today. Who's Jared Sandler?
I don't know.
I sat on the Supreme Court Rules Committee appointed by Justice Bales. Oh. I'm sure David will come back and be like, yeah, I ran the Supreme Court Rules Committee. I created and invented the Supreme Court Rules Committee. There was no
Probably.
Rules Committee before me. Okay. I sat on the Supreme Court Rules Committee appointed by Justice Bales and specifically was on a subcommittee that addressed Rule 26. I am confident that there are a myriad legal and factual issues here, and we will not be withdrawing any of our motions as sanctions are more than warranted. Wow. Without diving too deep into the issue, here are a couple of quick comments. Laura had noticed, if you only look at our motion to leave to amend, it contains detailed allegations about Rule 26 on page 5 through 6 of the amended answer. The motion for sanctions was not filed until January 3rd, so she was given written notice of the specific Rule 26 allegations more than 10 days before filing via the motion for leave to amend. There is also several emails and communications with Laura's parade of prior attorneys that meet the same criterion.
Drink.
Laura, right? Everybody drink. Whatever you're drinking.
3 times already, so.
Right? What are you drinking? Put it in the chat. I need to know what y'all are drinking too. Okay, so Laura would not have been able to withdraw her petition. Dismissing the entire petition after a response has been filed requires either agreement of both parties or approval of the court after a motion to dismiss. She filed a motion to dismiss before the motion for sanctions, which the court denied and expressly preserved the claims for attorney fees and sanctions. This is consistent with Rule 48. Court may dismiss a petition on such terms and conditions as the court deems proper. Oh my gosh. Including the resolution of any claims by the responding party. All this legalese. Texas tap water. Is that better than Louisiana tap water? Usually.
That's the coffee time.
I see a lot of coffee in the chat.
It's not a day drinking day today. I did that yesterday.
It's either coffee or water. All right, we can talk more about this over the phone because I refuse to sit down and eat lunch with you. No, it's not what it says. I just added that in there. But I will save the full legal analysis, including responding to the referenced Rule 11 case law, which is neither directly on point nor analogous to Rule 26,
Drink.
which is drink intertwined with Title 25 actions and legal distinguishable. I will also briefly point out that Rule 26, go ahead, I'll be just guzzling, permits the judge to move for sanctions on its own upon a finding of bad faith by Laura. I am confident that Judge Mata has all the authority she needs to enter sanctions against Laura based on the numerous filings that she signed that were both woefully improper and predicated on fraud.
Let me scroll that up for you there. Ooh, there we go.
Laura's efforts would be better spent complying with the uncontroversial rules like Rule 49 disclosure. Our experts are waiting for the miscarriage photos and the simple name of the doctor that she sent the image to per her testimony. Brian, is it Byron or Brian? Y'all keep interchanging the R and the Y, and I don't even know anymore. Brian Neumeister is prepared to examine the images as well. You said you had the information and they are beyond overdue per Rule 49. I trust you saw the discussion between Laura, Corey, and the judge on the issue of the alleged miscarriage in our most recent status conference. Again, this is not about you. You have been nothing but professional. Oops. Oh, that didn't age well. And we appreciate it. But we have had these conversations with her prior attorneys. We have been in front of the judge. We now have all these proceedings before Judge Mata, or at least the third should be en route after recent motion. I have also attached the unredacted email to lawyer's prior attorney in the blank, which Corey was copied on. If you'd still like to meet and confer, I can find time tomorrow, Greg. Lord.
I mean, he's trying. He's trying real hard.
That makes sense, Cheese.
What's that?
Brian. There was a sick after Byron, which implies that it was written incorrectly. They were just copying it incorrect.
I was kind of hoping it was Byron. Byron was better and gave him more of like a majestic name.
Lord Byron.
I'm about to order. Llama has ordered you, Brian, to change your name to Byron because she likes it better. You've now.
All right.
I have to do it.
What's next?
All right. Hold on just a second. I'm painting my last nail.
Girl.
Well, glitter.
How many fingers do you have? You've been painting them for a while.
A lot of fingers. For all the dry humping and finger banging. You need a lot. No. So it's like this, like, well, I don't know if you can see it, but it's like, sparkles. So like you have to do, several layers because it takes so many. It's annoying.
I can't paint my nails. I put my hands in water way too much because I do all the mom like washing of the dishes and crap. So that's just a waste of time for me.
Well, I feel like, sometimes you got to do just some self-care, even if it's just painting.
Yeah, but then I have to do it again. And I'll be like all sad because it looks like crap. So there's no point.
All right. So next we have from David.
Oh my gosh. It's weird to see your name in the chat.
Which one? Which one of us, though? Which one are you yelling at?
Which Tara?
We are Tara.
We are both Tara.
Yeah.
We have the same name.
Mm-hmm. It's true. True story. Okay. So this is from David to Isabel and Greg on Monday, April 1st. This is when he filed his extension of his 39-page extension of time. You're never going to be able to catch the live stream anymore. Today of all days, my new district manager stopped by, and I'm running the department myself. Oh no, rude.
Need a raise. Demand
exactly
a raise. We will write you an arts and craft project.
Yeah, why not? It's fine.
Telling you that you deserve a raise.
Yeah, it's fine.
I'll have ChatGPT write it
because we're professionals.
And we'll do like a 65-page motion. Why you should have one.
Yes, we will. We'll do that for you, Alec Fire. Cat. All right. So, Isabel, although most of these comments are for Greg, except the PS at the end. Me too, Tony. Me too, girl. So thanks for the response. And just to make sure my position is 100% clear, I'll give you a few response points. One, in my view, it is an undisputed fact that you never sent a written notice to Ms. Owens telling her that you intended to seek sanctions unless she corrected or withdrew her petition within 10 court days of the notice. That's the safe harbor notice required by the rule. And, oh, fuck, I just missed my nail. Damn it. This is also, I don't ever pay them. There's going to be glitter everywhere. That's the safe harbor notice required by law, and it was never given. Let's just concede that and move on. Hello, Rogue. Hello. Welcome. 2, yes, you guys sent other types of notices, mostly framed as settlement offers and or threats, but nothing that ever strictly complied with the 10-day notice and notice of the right to correct withdrawal requirement. 3, Gallagher, which we all agree is instructive but not binding, expressly rejected the idea that a settlement demand and or threat are enough to strictly comply with the rule. Quote, a demand for dismissal and a threat to seek sanctions does not transform a settlement demand into Rule 11 complaint notice. Duh. That's obvious. He literally wrote that. Duh. That's obvious. The whole point is that you must tell the other party that they have the right to drop the case, and you have to give them 10 days to think about it and accept the safe harbor if they want. The failure to give a clear notice of that is not harmless, which is why the court enforced this rule so strictly. 4, yes, Rule 11 and Rule 26, drink, are not identical, but only in ways unrelated to this issue. For the purpose of this discussion, the rules are identical. You know that, so stop wasting time by claiming otherwise. Gosh, guys, stop wasting time. As Gallagher noted, and I'm sure you will not dispute, Arizona courts look to federal case law construing and interpreting the rule's federal counterpart and a whole bunch of numbers. So the bazillion plus federal cases, which are all unanimous on this point, are going to be followed here. Because you failed to give Miss Owens the 10-day safe harbor notice, that's the end of the Rule 26 discussion. It's the end of it, guys. We're never going to hear it again. Drink. We are going to totally hear it again. Stable or stubborn, depending on the perspective. You cannot, as a matter of law, recover sanctions under Rule 26 as that motion currently stands. It's also worth noting you not only have failed to give Ms. Owens notice of her absolute right to withdraw her petition, you actively oppose her request to dismiss this case, which only needlessly increased fees for both sides. Guys, this all could have been over. Jeez. 7, although your current Rule 26 drink motion cannot be granted due to your failure to strictly comply with the rule, that does not mean the issue of sanctions is forever off the table. You absolutely could bring a new motion, provided you strictly comply with the rule. You just haven't done that yet. What that means is, let me explain it to you because I'm smarter than you. If you wanted to ask for Rule 26 sanctions, you would have to meet and confer with me, and then you would have to give a 10-day written safe harbor notice. If you did this, Miss Owens would invoke her right to withdraw the petition, and the case would be terminated. You could not then proceed under Rule 26 drink because the rule prohibits sanctions when a party accepts the safe harbor. That's the whole friggin' point here. Duh. I included that duh, but I'm surprised he didn't put it in there. Assuming Miss Owens withdrew her petition, you absolutely could still ask for sanctions under other authority. But not Rule 26, because the safe harbor prohibits this. For instance, you could ask for the sanctions under ARS 12349. You could also bring a motion under another one. I guess you could even invoke the court's inherent authority, but that doesn't add anything to what the ARS 12-349 already says. Are you giving him ideas of how to make your client pay for sanctions? Is that what's happening? Okay. Sure. Oh, yeah, there is the little puppy back there. Little Penny being all cute.
That one's Reese. The one
Oh, is
behind
it?
her. Yeah, Reese is a little girl.
Oh, well,
She's
it's a black bob with like brown feet. So I wasn't sure.
Yeah, that's Penny.
Oh, that is
I mean,
Penny.
that's Reese. Penny's behind her. I'm sorry, I got confused. Reese is like, I hear
Respondent,
my name. What do you
petitioner.
want?
There's their face. Look how cute she is.
Reese, Reese cup. Reese cup.
I love it.
What girl?
While you're navigating dinner chaos. All right, so the point here is really simple. You didn't follow Rule 26, drink, so you can't get sanctions under that rule. This is 1,000,000% clear. Oh my God. He is just like Laura, you guys. 1,000,000% clear. It is so clear. It is an issue I will absolutely, positively win on appeal if that becomes necessary. At the same time, all hope is not lost for your side. Shut up. There are other options available to you if you want to seek fees, but you have not made any motion seeking fees under these other authorities. If you think you have a factual legal basis to do so, go for it. What? Okay. Why would you say that? Okay. Okay. And just keep in mind, Miss Owens will be bringing her motion for fees under ARS whatever once we're done. And she will also bring a separate Rule 26 motion unless you withdraw your pending Rule 26 motion within 10 days. While I feel like I already said this, it's worth saying again because I want you to feel like a fucking idiot. If you withdraw your Rule 26 motion within the next 10 days, I cannot ask for sanctions in my own Rule 26 motion because you will have availed yourself of the safe harbor. If I was in your position, I would seriously stop and think about that before telling me to go fuck myself. You can literally avoid about 35,000 in risk simply by admitting you made a mistake and then doing the right thing. If you decide not to take the safe harbor, it's your decision, but a pretty freaking bad one. P.S. One final comment that I think should be mentioned, Isabel. I know you're a new lawyer and none of my comments or hostility are directed at you. Getting familiar with the practice of law is hard. This motherfucker. And it takes time. So please do not feel any concerns about me threatening sanctions towards you or whatever, because I'm not. If we have to go down that road, the dispute will be between myself and Greg, not you. I will make it clear to the court that none of these arguments are directed at or towards you because you're a woman. And so, therefore, you don't know better because you're dumb. He doesn't say that, but that's how I'm interpreting that.
No,
Oh my
you see,
God.
it sounds like he's the guy that holds the person for ransom and then lets you know, don't worry, I don't want to hurt you.
Yeah.
But
Smart.
like that's what it sounds like. Like he holds the, I'm holding you hostage. I'm making you my hostage, but
Right? Oh my
I know you just
goodness.
don't know any better.
Oh, look. Say Cheese says their avatar wants to see Buffy's puppy. Look at their cute little fur baby in there. I love it. Oh, you guys are so cute. This guy is something else. All right. Boring tax lady says, I think Chingris found his license to practice law in the bottom of a box of Fruit Loops. Allegedly. Allegedly. Okay. So, oh, there she is. Oh, look at those curls. I love it. She's so fancy. So fancy. Oh, so cute. All right. So this one is from Isabel. The same day, Monday, April 1st. Wait, hold on. Is this before or after? His was at 11:39 a.m. This one is before the one that Gingras just wrote at 11:08 a.m. So this is from Isabel to David. I'll read this one if you want me to, Buff. That's fine. David, Greg and I are both occupied, but we will be able to call you later this afternoon once Greg is out of mediation. Surprised he didn't call her sweetheart and told her she should just, right? Listen here, sweet cheeks. All right, you just go sit in that corner and rest that pretty little brain of yours. Okay.
He's condescending.
He is. He is. He needs to be on the call as he is primary on this case. Also, your request to meet reasonable did come over the holiday weekend, and I don't think the court expects us to drop other obligations to get on the phone the same day. Still, we will do our best to make it happen this afternoon, as Greg just messaged me that his mediation with Jared Sandler is moving along. Wait, did you read this already? No. That was just the
No.
second time we've heard. Who is Jared Sandler? Who is it? I don't know. Rule
Well, we
20
heard them mention him, but
I
that's why I
know.
said he said he was having a mediation with him, and I was like, "Who is that?" Maybe it has nothing to do with this case, and they're all just like know who that person is. I don't know, but that's the first time I've heard that name.
Right? Here is a brief assessment of a case law you cited. Please note, this was gleaned in roughly 20 minutes of research, and there is certainly more to follow as this is not comprehensive. 1. Rule 26, drink, differs from ARCP 11 and FRCP 11 because it pertains specifically to Title 25 actions where there are numerous legal authorities for awarding fees and sanctioning litigation misconduct that do not exist in other state civil or federal civil actions. The main case cited in the emails are Rule 11 cases with limited distinguishing facts and circumstances. Assuming arguendo, these cases apply in analogously or whatever to Rule 26 drink, which is not a fair comply. Here are some issues with them. Okay. All right. I don't really know what they're talking about, but that's fine. Holgate is a federal case regarding FRCP 11. In Holgate, there are 3 parties seeking Rule 11 sanctions. The first party complied with the notice requirement rather uncontroversially and received a sanctions award. The second, the Newell defendants, filed a motion to join the prior motion for sanctions and serve the opposing attorney the day they filed the motion. The court found the safe harbor period commenced when the Newell defendants simultaneously filed their motion and served the opposition, then filed another motion for sanctions, later requesting sanctions against the same party. The court found he received sufficient notice, right? Sufficient notice and affirmed sanctions. And this posture is very similar to Clayton's motion for leave to amend, in which he discusses in writing the intent to have Laura sanctioned under Rule 26, and the later motions for sanction more than 10 days after serving the motion for leave to amend. If the motion for leave to amend serves as written notice, as the initial motion did in Holgate for the Newell defendants, there is no error, and Laura received adequate notice. Note that she also moved to dismiss her complaint during that time. So not only did she know a sanctions motion was forthcoming, she attempted to withdraw the complaint. The court denied the motion to withdraw the complaint and preserve the fees and sanctions claims as ARFLP 46 allows. Okay, so since she already filed the dismiss, why would she get the opportunity to get it again, I guess? Oh, wait, somebody was explaining who Jared was. where was it? The Jared guy. Well, he's passed away. All right, I don't know who the Jared guy is. Okay.
Text packet said he was a different lawyer.
Yeah. All right, hold on just a second. Go take a nap, Lick. Go take a nap. I've ordered you to do it. I demand it. I demand it. Okay. So the court denied the motion to withdraw the complaint and preserve the fees and sanctions claims. I already read that, but whatever. ARFLP 46 allows. Only the last claimant in Holgate, called Community Bank, had their sanctions award overturned for improper notice. And that claimant waited 10 months after the other parties filed their sanctions motions to take action. By the time they filed, the attorney against whom they sought sanctions had been withdrawn from the case over 5 months. The court found this was too long because the attorney had no power to counsel his client to withdraw the offending complaint by the time sanctions were requested. The court also rejects the argument that there were alternative sources of authority for sanctions as a cure of the Rule 11 problems because the federal authority requires a finding of bad faith the court expressly did not make. Oh my goodness. Okay, well, we're learning a lot of stuff today, I suppose.
Oh, it's a lot of legalese.
Sure is.
I like they're all screwed up.
All right. Barber is a Ninth Circuit case applying FRCP 11. In that case, the parties seeking sanctions filed their motion after the complaint was already dismissed without complying with the notice requirement. The court found failing to comply with the safe harbor provision defeated the motion and declined to treat the award as one given by the court's own motion because the rule does not allow the court to take this action after judgment, and there was no evidence in the record that the court would have made a sanction on its own as a show cause order because that would only occur in situations akin to contempt of court. I hate civil law. Can I just tell you how much I hate civil law? It's so pedantic and ridiculous. Ugh, criminal law is a lot more just, easier because, like, you got, some constitutional rights throw in there, all sorts of things. Ugh. Ugh. Hi, 80s. Hi. Let's see. Gallagher is a trial case and not binding precedent, but the analysis given therein is relevant. Gallagher says that the safe harbor provisions of ARCP 11 are construed strictly and failure to comply defeats the motion. It further says that a mere demand to dismiss a case and a threat to seek sanctions does not constitute a compliance Rule 11 notice because it did not give specific notice of the offending conduct or the 10 days in which to withdraw or appropriately correct the alleged violations like the rule requires. Laura did have specific notice and more than 10 days to correct after the motion for leave to amend. And she did, in fact, attempt to correct by moving to dismiss the petition. The court declined to dismiss the petition and specifically preserved the fees and sanctions issues, which it has the authority to do under Rule 46. The court also rejected an independent allegation of entitlement into sanctions, but it did so mostly because the party seeking sanctions did not address the statutory factors or identifying facts in the record supporting a finding of bad faith necessary under the statute. Clayton has articulated claims for fees under the appropriate Title 25 statutes and the relevant factors therein. We will flesh this out further in the anticipated response to the motion. We will call you as soon as we are able to, which should be later this afternoon. Isabel. All right. And then Greg. This is David to Greg, Monday, April 1st at 9:58 a.m. Oh, great. Oh, great.
The first line.
Greg. I know you are not going to concede the Rule 26 drink issue, so we're obviously going to have to litigate that point. I
Mm.
provided you with substantial case law that directly refutes your comments below, and your response cites nothing to contradict this. That's not surprising because we both know your position on this is wrong. It's not just wrong, it's sanctionable. I'd like to get this issue in front of the judge immediately because it is going to be depositive. It is
Dispositive.
dispositive. Thank you. I was laughing so hard, my brain couldn't do two things at
I
once.
was just like, yeah, that has a different meaning if you say depositive.
I'm just a woman. It's fine.
You're
What do I
silly,
know?
silly girl.
Mm.
It's
It is
cute. You're
also going to save a ton of time fees for the parties. Fees which we will be asking the court to hold you personally responsible for. So it's in your best interest not to drag this out any longer than necessary.
oh, he's getting ugly.
Hmm. In order to not delay this any further, we need to discuss this today. Since both of our positions are pretty firm, I think this should require about 30 seconds of time on the phone.
I doubt that.
Okay, sir. Sure. There is no reason you can't step out of the mediation for 1 minute to speak with me during a break. So please let me know when you'd like to do this, assuming Isabel is not available. If you refuse to talk, that's fine. I'll explain that to the court in my certificate. I've given you a clear explanation of my position, and I think you have made your position clear as well. So I don't think we have anything further to discuss. But in order to comply with Rule 9, I'd like to speak to either you or Isabel today. David.
The audacity. There's no reason. I deem that. You have
Oh my
you can
gosh.
step out of a meeting to talk to me. I'm sorry. Who are you?
Right?
Like how did,
Oh my goodness. This fucking guy. Yeah, it's only going to take 30 seconds, and you're wrong. He is a chode.
guy, we've read all of your motions. You don't do anything succinctly. I
No.
seriously doubt anything you had to say on there was 30 seconds. But okay.
Oh my goodness. This fucking guy. He's just desperate as low. It really is. It's wild these two met up. Like,
But the audacity to tell somebody that you have the time, okay? Like you know what goes on in like his day. I don't know.
LMP. Pretty sure there's only one thing dingoes can accomplish in 30 seconds.
You get the best comment award today.
Allegedly. Allegedly. We don't want to hurt anybody's feelings. Oh my gosh.
Yeah, because he would have his feelings hurt about that.
And Bill Marie says, I love that Mata and the appeals court left at his Rule 26 argument. Isabel explained to him case by case why his analysis on Rule 26 was wrong. I mean, it's so funny that he does go after these things. I mean, I don't fucking know. I'm not a lawyer. But, they tell him what is his client really is like. And he's like, I got to find something else. I got to find something else so we can ignore all the actual problems with this case. Let's just tie up everybody's time and fees. I love how he's like, oh, the fees, guys. And he's just like sending email after email, call after call every single day. Like, bro, shut up. You know what you're doing. All right. So this one is from Woodnick, right? Wait, hold on. That's 934. Oh, okay. So that was the one responding to Woodnick's here. So it's you, boo.
Okay. David, I appreciate that your effort to excise Laura from this mess she caused, but we read this already.
Oh, do we? Okay. We'll skip you. Oh, yep, you're right. Correct. All right. All right.
Yeah, Greg, what are you doing? You're duplicating emails. That's a Laura thing.
Okay, so this looks like this, though, is written from David. Yeah, this is definitely written by David.
You
So
picked the David. You picked David.
I know. David! Okay. In the response filed by Alexis, I see she raised the issue properly, but only briefly. And in the reply, there is an argument that the requirement of Rule 9 were met and or were impossible to meet. However, the reply is entirely silent about why the 10-day notice requirement of Rule 26 blah, 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 was completely ignored. God. In light of this, I would like to schedule a time to meet and confer with you about this issue per both Rule 9C and Rule 26. I am available anytime on Monday, so please let me know what time I can call. Here's the problem. He's going to tell us. Don't worry. He loves telling us what all the problems are. Here's the problem. Under Rule 26, if the required 10-day notice has been given, Laura would have had an absolute right to withdraw or appropriately correct the alleged violation. She would have had an absolute right to withdraw her petition and dismiss the case, subject only to Clayton's right to seek fees. That is the outcome required by the rules, but which is what's going on. I don't understand why he's so pedantic about this. But okay. Obviously, if Clayton did not comply with the 10-day notice requirement of Rule 26, then he cannot seek or receive sanctions under that rule. That makes sense because by failing to comply with the rule, Clayton deprived Laura of exactly what the rule requires: a safe harbor, which includes a right to withdraw a claim in order to avoid further litigation expenses. Under these circumstances, I need to be clear about my plan. Absent some other explanation, I intend to file a motion to strike your Rule 26 motion based on the apparent failure to comply with that rule. I'm Rule 26 is why I don't do drinking games, right? Jeez Louise. I also he's like, I'm gonna file a motion to strike, but what I'm actually gonna do is I'm gonna put it all in my I need more time to reply to this motion. I'm just gonna put it all in there together for a judge as I ask for more time. So let's see. That motion, if filed, would also include a request for sanctions under everybody Rule 26 and fees under ARS 25, whatever, for all fees and costs that Laura has incurred from January 3rd, 2024 to the present, and all fees that Laura continues to incur while this matter remains pending. Well, I am happy to give you a more detailed written explanation if you need one. You should construe this email as your 10-day pre-filing notice per Rule 26, because the old version of Rule 11 used to require an actual draft brief be sent to the opposing party. I will probably also do that just for redundancy after we talk on Monday. And yes, I understand you may take the position that this issue is either already before the court, since Judge Mata set a hearing on the motion for sanctions, notwithstanding Alexis' very brief remark, or that Judge Mata has somehow impliedly, okay, ruled on the issue by setting the hearing over Laura's objection. If that's your position, we can obviously agree to disagree like just normal people. It's fine. He can do that, you guys. He can
I'm
do
sure.
that.
I don't think he's capable.
I guess it is also possible that I'm missing something. I know you had one or more hearings before Judge Mata since January, and it is possible this issue may have come up and she may have made some sort of verbal ruling, not found in any minute entry that I've seen, in which she determined that Rule 26 did not apply for some reason. If that is what occurred, I would appreciate whatever details you have about the court's verbal ruling, as this would be subject to revision through alternative means. This is obviously a significant issue, given that by the time this matter reaches trial, the fees incurred on both sides will likely exceed $100,000. Well, he's not wrong, but David, you're making it very expensive as well. It is also a clear error of law, which would be an easy matter to reverse on appeal. If the judge were to consider a motion for sanctions that was filed in complete disregard for the 10-day notice requirement, because there is substantial financial value in this issue, and because the law is so clear on this point, I obviously intend to litigate this specific issue as far as necessary because the rest of my cases, it's a dumpster fire. We're never getting anywhere with that. So we need to have a thorough discussion about it, and soon. So please let me know when we can meet and confer about this on Monday. Thanks. Yours truly, David. Okay, more David. More David. So David, right? Yeah, we'd all be dead from this Rule 26. Say Rule 26 one more time, motherfucker. I know we're all tonight just going to be laying in bed, and it's just going to be Rule 26. Rule 26. Oh my gosh, he is the worst kind of pedantic. He is. I don't like people like that. Like, grow up. All right. I mean, I get it. It's law, but also grow up, David. Let's see. All right. So this is Thursday, April 4th at 1:30 p.m. Greg, thank you for the email, and your words are noted.
Are trash. No,
I'm sure he says that at one point. If he doesn't, he will, I'm sure. I am obviously a passionate person, and my words sometimes reflect that. I do my best to remain professional with you. I am allowed to be upset when I see something that I think crosses the line. I didn't even know David knew there was a line compared to like reading his blogs.
He's like, don't invalidate my feelings, Greg. Jesus.
It's ridiculous.
I'm allowed to have feelings, Greg.
Yeah, cheers. I'm just passionate, okay? And I don't think things through. You're a fucking lawyer. What? You shouldn't really be letting those things get in the way, David. Oh my God. Okay. I don't want to escalate the debate, but as much as you may have concerns about my words, I also have concerns about your conduct. Lying to me and or lying to the court are much more serious problems than me tweeting comparisons to an MMA star. You're right. Your client is in some serious problems for lying to the courts, David. But you have asked to tone stuff down, and I agree with that view. So I'm not going to push the issue further at the moment until probably 2 paragraphs from now, unless given no choice. So give me another choice. That's very Laura. Like she was when Clayton would respond, she'd be like, you didn't think about it long enough. So you responded in 7 minutes, and I don't think that's even possible. So I think you should really take the time and think more on it. As for the other points you mentioned, a few comments. First, I am aware of no court order that would stop Laura from publishing her own medical records. Yes, I am aware there is a minute entry order dated 2/21/24 that says, among other things, no party shall disclose outside of themselves, odd wording, any medical or other documentation disclosed between the parties. So they finally gave him that evidence, and he was like, but we're just not going to pay attention to it. This is not that. I was obviously not present when the order was entered, so I may not have the full context. But my reading of this is if Laura discloses medical records to you, you can't share them publicly. And if Clayton shares records with us, we can't share them publicly. I don't think so. I don't think that's how it means nobody. Nobody do it. That's typical. And it is how I read the court's order. If my reading is correct, it does not prohibit Laura from posting her own medical records, which she did solely to rebut false claims from your side that no such records exist. There is nothing nefarious or improper about this. If you interpret the order to mean that Laura is somehow enjoined from publishing her own records for the purpose of responding to false statements other people are making, including Dave Neal, who Clayton is clearly working directly with, you need to let me know that immediately so I can take the issue up with the judge. Okay.
Shouldn't you have done that first? Usually you seek clarification for the judge if you're not clear on a ruling.
Right? Right? He doesn't want to escalate things, guys. He is very easy to work with. Does David have any other client? That's what I want to know. Like, how do some of these people have the time? But maybe it's because they don't think about what they say. So it's just a pure stream of consciousness that they get it done so quickly. That's my only
I mean, that's the only way
reason
you
I
could explain
Yeah.
this rambling nonsense.
Yep, just straight stream of conscious. Because they don't seem to think, maybe they shouldn't say some things. But they're just passionate, guys. They're just passionate. There is clear case law on the issue. A court could never issue such an order, which is why I give the minute entry order a narrower reading. Any broader reading would make the order unconstitutional. I don't think that's true, though. I mean, that's how it is in criminal law. You can't release anything. Nobody can. Like, including the defendants or the witnesses or the victim, like literally pretty much nobody on a gag order. I don't know. I don't know if it's the same for civil law. I don't know. But you'll get in big trouble. It's a big no-no. So any broader reading. Oh, go ahead.
I would assume like that you would interpret it as broad until you have otherwise clarified whether it's a narrow, like you read it narrowly, right? Like
Right.
you would see clarification. I'm going to assume it applies to everything until I'm told by the judge, because that's what I do. See clarification if you don't understand. It's not very hard, but he likes to do things and then ask for forgiveness later. You know what I'm saying? He likes to like,
yes,
do it and then make
do it and ask for forgiveness later,
Yeah.
which is, I fucking hate that saying so much. Like, no, just don't be a dick. And then you want to ask, if you have to ask for forgiveness, then it's not a good idea. All right.
Right. Like if you think you might have to ask, you probably shouldn't.
Probably should. Yeah. Now, there is clear case law on that issue. Oh, wait, I already read that. Whatever, we'll do it again. A court could never issue such an order, which is why I give the minute entry order a narrow reading. Any broader reading would make the order unconstitutional. In fact, the order would be void ab intino, or whatever, I don't speak Latin, meaning it could simply be ignored. I know this because I've litigated this identical issue in other cases. Humble brag, David.
He's so smart.
Yes. See Phoenix Newspapers Inc. versus Superior Court, 1966. What? Okay. Holding order prohibiting disclosure of details of court hearing violated Arizona Constitution and was void. Superior Court has no authority to foreclose the right of the people and the press from freely discussing and printing the proceedings held in open court. Right. But that doesn't seem like the same thing to me. So, oh my God, text packet, just turn it off.
Well, you're just not interpreting the law the correct way.
I'm a dummy.
If you had done as many trials as he has done, you might know better.
Right. I mean, yeah, the press can talk about it as well. All right. But it wasn't said to the press. It was said to both sides. I didn't think there was any, I thought it was a pretty straightforward order there. But, David.
I mean, it made sense to me, both sides. She said both sides. I would just assume it meant everything.
Exactly. And I'm some lady. Why all the hoo-ha about sealing everything if you're just going to release it to the public anyway? Exactly. To eat time and eat resources and be a whiny bitch. That's why. Um, why does it say 92 people, 94 people watching and 5 in chat? I don't know. That doesn't seem right. Everybody say hi in the chat so we know everybody's awake. Okay. Now, let's see here. Okay, this one's from Greg. Was this before or after?
Everybody put
Okay.
tomatoes in the chat. We're throwing tomatoes at Jingris.
Mhm.
David.
So this is 1:30 p.m. And then this is 12:56 p.m. So this is what Nick wrote to David that made him respond that way. So wait, did we?
David.
No, we haven't done these, but okay. You ready?
Oh, I get to talk. It's my
Yeah.
turn. Okay. David. 1. While I appreciate your right to speak on all issues, I am deeply uncomfortable with the tone you are using in emails to my office, on Twitter, and in your blog. 2, comments like, I am the Conor McGregor of litigation, and I look forward to reading their obituaries, really evoke something extremely unpleasant.
Mhm.
Using the term special ed in a derogatory way is also not something I am comfortable with either as a lawyer and a parent. 3, I have never tweeted in my life. There are certainly passionate followers on this case from Bachelor Nation due to your client bringing the matter to the world's attention. That said, I was forwarded some of the postings over the past few days, as well as your recent blogs, and I am just not sure why you are engaging with them. We don't. I am also not certain why you are publishing court documents and your client's personal medical records contrary to court order. Laura needs to comply with the order and provide disclosure. The court will probably give us a few weeks to submit China doll affidavit, or I'm guessing it may just tell us fees abide trial. That will be up to Judge Mata. Greg.
I think Conor McGregor is the MMA person they were talking about.
Yeah,
I don't know.
he's a
Is he? I don't
fighter.
know. Oh, okay. All right. So this
Conor
is
McGregor is an Irish professional mixed martial artist in the UFC. Sorry.
Okay. No, that's fine. So this was sent from David to Greg before the one we just read. Greg, prepare to be surprised, but for once, I am not going to be a jerk.
Everybody.
What? What? I'm going to show you I can be reasonable. Sometimes. Here's the deal. You keep asking to tone things down. Honestly, I do share that view. Let's see if we can do that. Here's what I'm asking. Oh gosh. You submitted your order to the court on the MTC, and obviously, I'm guessing you plan to apply for fees. I don't want you to do that right now because it will cause additional unnecessary work for both sides that I think we can avoid just through a very minimal compromise. Oh, okay. We're going to compromise, guys. As a compromise, I offer this proposal, and I said I'm not going to be a dick. So let's see. Don't apply for fees right now. If you win a trial, you can ask for all the fees you want, including the motion to compel fees. In fact, you can basically say the MTC ruling entitles you to that part of the fees, even without a finding of frivolous or whatever. So basically, I am not asking you to give up anything other than the right to seek fees now. You can do that in 60-ish days when the case is over. Why does it matter? What's his reason for that? I don't understand.
He
I don't
doesn't
understand
either.
that.
He just wants to be adversarial.
Right. In return for you not seeking fees right now, I will agree not to bring a motion asking for relief from the MTC order on the basis of fraud. Like I said,
Oh,
I am not happy about what I have recently learned. But if we can avoid fighting over the new issue now, it would be helpful for both sides. What did he what did he learn? What? Okay. Also, in return for you not seeking fees now, subject to your right to seek them later, Laura will go ahead and comply with MTC order today. To be
pretty
fair,
sure she has to,
she has
no
to
matter
do it anyway.
what.
Yeah. To be fair, she says most of the stuff you are asking for does not exist. So
Oh,
this is
okay.
not a huge concession on her part, but at least it is something. Oh my gosh. Okay.
I don't know how that helps your client. This stuff doesn't
Mm-mm.
exist. Well, that's kind of the problem, isn't it?
Mm-hmm. Yes, exactly. Yeah, he's pulling a Laura here. Oh my goodness. Bonus point in an effort to be even more reasonable. I will also throw out something else because you've already deposed Laura and because some of what she discloses may raise new questions. What if we were to schedule a conference call with you, me, and Laura, and you could ask some follow up questions about anything new that she gives you? What, David? What? Okay.
This sounds like a trap.
This is very much sounds like a trap. It's a trap. What? To be clear, Laura hasn't actually authorized me to make that part of the offer,
What?
but she has shown herself to be completely open,
He's just making
honest.
offers without talking to his client first?
It's okay because Laura is so completely open, honest, and reasonable at every
But that's
stage.
not okay. Like, he's not supposed to do that at all. Like, you got me saying at all.
At all.
At all. Like a northerner. Like, what is that?
Oh my goodness. She appears to be an open book, at least since I've been involved. Oh, wow, sir. Wow. Okay. I am sure she would be willing to do a call, provide we limit it to some reasonable amount of time. If she's so fucking reasonable, where's her shit? Why does she have to be ordered to comply? She is anything
I
but reasonable.
I'm just so shocked by that hey, you know what? You could just ask for follow-up questions. It won't be on a transcript. There's no witnesses. It's just
Yeah,
us three, no transcriptions. Like,
totally. It's fine. It's a trap. And
it's a
yes,
trap.
and yes, I know phone calls aren't as formal as a depo. So what? That really doesn't matter. Laura is an
It does.
available witness, so you really don't need to admit her depo testimony at trial, except for impeachment, which that's exactly what they're going to do, David. My point is that even if a phone call doesn't give you admissible testimony, it still gives you helpful information you can use to decide your next steps. If you have questions and Laura points you in the right direction to where you can confirm her answers, that would save you the time and money of a depo. Plus, I think court reporters are overpaid anyway. So I just don't want to waste those costs. Think about this and let me know. Tone will remain down, David.
Greg, come here. Come here. Just between me and you.
It's fine.
What did you think when you read that?
Mhm.
Did you just bust out laughing? Like, come on, I won't tell anybody. I need to know.
That's
Like,
crazy.
that's crap. Oh, I mean, you don't really need it to be admissible. Come on, it's just like, Greg, come on. Did you
Fine.
laugh? Did you laugh? Did you punch a wall? Like, how did you respond to this?
I mean, he's told him several times, I will not deal with Laura without recording of some like he said it before he even came around. court reporters out there catching straight. Right? What a fucking dick, David. Where's her little, don't be a dick.
You're a dick, David.
You are a dick. How dare you? They type so fast. But anyway, wow. Okay.
I just
Oh, there's more. Or wait, no, this is the same one. There's the bonus plane, David. Oh, what is this?
a grave rubbing.
But Nick, for real, get your fucking shit together. This is annoying. We're at 150% enhanced. What is this fucking garbage? Okay, now I got to take out my whole screen. Hold on, I got to move all you guys over to this one so I can still see you. Greg, what the fuck? Yeah, I'll just. Oh, it is from David anyway. So okay.
You're welcome.
Monday, April 8th, 2024, 3:06. My comment's back in blue. One disclosure. I should not have to keep asking for the missing information which was required pursuant to Rule 49 and the motion to compel. You have stated several times in emails that you have the photo your client testified. Oh, he's taking it from there. Okay. Testified to taking on the day of the miscarriage, which has yet to be provided, and it appears you are now saying it occurred in November, contrary to your client's testimony at deposition and statements at the prior status conference. I assume you also have the telemed doctor records and contract information so we can obtain the records with the photo from the source directly. Again, I should not have to keep asking about this as the court granted the motion to compel. These are DG comments. There's obviously been a lot going on, and I don't have unlimited hours in the day, okay? I'm not holding anything back. I'm just trying to prioritize things. And who cares if there's an ordered motion by a judge for my client? I got blogs to write and tweets to tweet or whatever, however that works. Has the judge actually signed the MTC order you're submitted? Has she? I don't know. I'm too busy to check. If she did, I have not seen that. Assuming the order has been entered or is entered soon, I am obviously going to comply with it, but I still feel we have other things to discuss that may relate to that order. Among other things, when I first got involved, I did not know, but obviously know now, that Corey Keith gave you a detailed disclosure statement on February 23rd, 2024. In your MTC filed on March 11th, 2024, you told the judge that Laura had given you no disclosure at all for 8 months and that she had only recently provided minimal disclosure. But things were totally and completely false. In addition, because you refused to give me sufficient time to review this stuff, I did not know, but now understand that when you filed the motion to compel on March 11, 2024, the only basis you had for the motion was Laura's general disclosure duties under Rule 49. In other words, this was not a situation where you served a specific request to produce or interrogatory that Laura failed to answer. The only basis for your motion was Rule 49. But on February 21st, 2024, the court issued a minute entry order which provided as follows. The parties shall complete initial disclosure no later than 45 days from today's date. 45 days from February 21st is April 6th. And based on this, it is clear you filed a motion to compel on March 11th that sought information that Laura was under no obligation to produce until April 6th. I'm sorry, but there is no other way to say this. That is absolutely unbelievable misconduct. How dare you, Woodnick? Never seen anything like it in all my years of practicing. Mm-mm-mm. The bottom line is that I'm willing to work with you to try and de escalate this conflict. If you are interested in that, we have plenty to discuss. On the other hand, if you want to pound your chest and demand that I play by the rules when you have shown a total disregard for the rules, that is not going to be productive. So let's try to be productive here. That starts with talking. And while I should not have to say this, it absolutely 1,000% must involve complete and total candor. Candor towards me and candor towards the court in every communication without exception. This fucking guy, man. Oh my God. 2. Lunch. This is Greg. I appreciate the lunch invitation, and I would consider the free food after your client complies with her obligation. She has admitted to forging medical records from Smile, and our experts need the original, which she testified came from Planned Parenthood. And as you've seen, Planned Parenthood indicates they have no records that show your client was there for an ultrasound on the day in question. Our experts, medical and New Meister Tech, are waiting for the documents, and the motion to compel was granted. I will eat with you sushi after we have the information for the experts. Not a sushi fan. Nope. But I do like Kona Grill. So if that's a fair compromise, let's do it. I actually tend to not eat much during the day. I am getting fat and old. So the whole lunch thing was really a metaphor that I used the whole case to talk about it. But okay.
No way.
Uh-huh. Would rather meet you for a beer and some nachos, like besties, because we're just cool guys. Do you shoot pool?
He
Stop
wants
it,
a friend.
Stop it, David. Oh my
So-
gosh.
Laura has to write relationship contracts to get a man, and David has to have motions to compel to have friends.
Yes.
Wow.
This is very embarrassing for you, David.
It's so embarrassing. Like, I would have never, ever written that. Like, you and Laura are a match made in hell.
That's right. David wants a friendship bracelet.
Oh my gosh. Oh my gosh. Oh my gosh.
All right, so let's start that little part over again. Would you rather meet for a beer and some nachos? Do you shoot pool? Happy to meet you somewhere for some friendly games of pool. I'm not a good golfer, but Top Golf would be okay as well. Your call on where, when, and what. Okay. 3. Media by Woodnick. Any issue you have with reality Steve Carbone or the others who have covered this story after your client initiated this with the Sun is your issue. It has no bearing on the litigation and is not something Clayton would be spending on legal fees. Just a second. Somebody's knocking my door. You carry on, please. Thank you.
I can't read it because it's too small. So we're just gonna have to wait until she gets back. So y'all can just hang out and talk to me. My bifocals are new. They're good, but they're not that good. So, I don't know if I can put that comment on the screen, barbecue queen, or I'm probably definitely getting a cease and desist. But that's actually really funny. Oh my gosh. I feel like I should have changed the thumbnail today to David with like beer and nachos in his hand or something. That's so funny. I just can't believe how similar those two people are. That is so crazy. All of that wasn't even real. Like, it was completely fake. Oh, I that's crazy. Let's see if I can pull it up and make it bigger on my end because I cannot see what she has at all. I can't even see what document she has pulled up. Why is this writing like so small?
All right, I'm back.
I didn't read
All right.
nothing because I can't read nothing.
I know it's so bad, right? Sorry, there's like a internet person at the door.
Oh no. I was like, girl, I can't read that.
I know it's really bad. All right, so where were we?
I have no idea where you are because I
reality.
can't read.
We're at media. Media. Any issues you have with reality Steve Carbone? I'm just seeing if it's picking up their conversation. Or
It
the
is.
others who it is it. Oh my god. Okay. Oh, I'm not even on camera. There we go. Oh my goodness. You had to reload your stream because it was acting up. Oh no.
I appreciate you. I know it's just your job, man. It has nothing to do with you.
Why is Bea so polite?
Yeah.
Have a good one.
I fucking hate the internet people. They're relentless, is all I'm saying. It's like we already have like the best internet out there, but sure, okay. Anywho, all right, let's resume into this batshit crazy thing. Media. Any issues you have with reality Steve Carbone or the others who have covered this story after your client initiated this with the Sun is your issue. It has no bearing on the litigation, and it is not something Clayton should be spending legal fees on. This is what Gingras has to say about that. No clue what you're talking about. Are you kidding me? I thought you said you read shit.
No,
I have not.
He didn't.
He didn't read anything.
No, he didn't.
Oh no, it wasn't on purpose, the cam thing. It's because my brain is already, it's so much dumber from all of this. No clue what you're talking about. I have not reached out to Reality Steve yet.
Oh,
Why is Clayton spending legal fees on media? I am not charging Laura for anything I'm posting online. That is just me expressing my views about stuff. I don't charge clients for that. What is even? How did you come to that conclusion from reading? Okay, okay, David. Experts. I understand Rule 702 and did not need the explanation. These very qualified experts are awaiting documents that you ostensibly have or confirmation that the photos and supplemental medical records Laura specifically testified to having do not exist. At this rate, you might not have their reports before 60 days, but that is only because your client has refused to provide the same. The disclosure you received provided a summary of their anticipated testimony pursuant to Rule 49J. I will have more data for you as soon as Laura complies with her disclosure obligations, which, again, we have been requesting for a long time. All right, Gingras, what you going to say? Again, if you would simply speak to me, Laura fucking said the same shit in her messages. The same thing.
they're the same person.
They are the same person.
Do you think? Never mind. I was just thinking, do you think they're related
Oh my gosh.
somehow? Like long lost dad or something? I don't know. He just seems like
What are the fucking odds? Like, oh my God.
they're exactly the same. It's crazy.
It is. Again, if you would simply speak to me, I think you would instantly realize there are ways to simplify this dispute. In fact, in the spirit of trying to show what can happen when we communicate, let me share some information with you. She fucking said all the same stuff to Clayton. Literally. Like,
I know, but it's crazy though. It's like I want to have like lunch with you, and as soon as Greg was like, "Okay, I'll have lunch with you," it was like, "Nah, I don't want lunch."
let's go do
It's like as
something
soon as you give
funner.
the person, it's just, can I get you to capitulate to my want? And then when you finally
Right?
do, I want something else. These
Fascinating.
people,
Fascinating. Oh my gosh. As I mentioned before, I have the photos you want to see. I understand you want to give them to your experts because you don't truth the image dates. Greg, that is not going to be a problem. You are going to love the image dates because the images are dated July 23rd, 2023. Still, think you need an expert to debunk the dates? I would expect not, because I can already tell you my client is a fucking liar and made them up. Oh, not that this matters, but I also have text messages between Laura and her sister dated July 23rd, 2023. Again, arguably helpful for you, but certainly not dispositive of anything.
I'm sure, are they like actual copies, or are they pictures of
Right.
copies? Like, you know what I'm
You
saying?
don't
Like,
need
how
it.
did she get them?
I know the judge ordered us to give it to you, but you don't like really need it for anything. It's not
Bruh.
important. Also, I do have some telehealth info showing Laura seeking medical advice on July 23rd, 2023. I don't think this is helpful to either party, but it is something I am willing to disclose.
At least
Sean.
Clayton got 2 BJs before he started being harassed. Poor old Woodnick.
That's
Oh my
amazing.
gosh.
Where were we? Let's see. But here's the thing. I am still on the fence about getting you. This is so much like fucking Laura. I'm still not sure if I'm going to get rid of the baby or keep it. And I'm going to let you decide that. Okay. But here's the thing. I am still on the fence about giving you the photos themselves, unless you agree to not publicly disclose them prior to trial, if there is a trial, given the incredibly inappropriate circumstances which resulted in the MTC order being granted. I've still not decided if I want to fight the order further. It really just depends on how reasonable you are.
Oh
Greg.
my god.
I can't believe a grown ass man lawyer is writing this right now. If you are reasonable with me, I will be reasonable back. But it's hard to reach a conclusion about which side you're on when you won't speak to me. Guys. Oh my God. He's so ridiculous. They're the same person. They are the same person. Oh my God.
Is
All
this
right.
like
Not going to be ignored.
Yes. Yes. Let's see. These are just things that we've already went over. So do. Oh my God. Okay. So this is from this is what David was just replying to. So this is from Woodnick to David.
I
Well,
can't
go ahead.
see that.
Oh, you can't. Okay, that's fine. All right.
It's
got it.
so small.
I know it is. It's ridiculous. Here, let's see if we can even just make it bigger. I probably still won't be able to, but oh my God, that's too much. That is at 300%. What in the fuck? Come on. David, one, disclosure. I should not have to keep asking for the missing information, which was required pursuant to Rule 49 and the motion to compel. You have stated several times in emails that you had the photo your client testified to taking on the day of the miscarriage, which has yet to be provided, and it appears you are now saying it occurred in November. contrary to your client's testimony at deposition and statements at the prior. Well, let's see. How many of these are there? You know what? We already read these. We don't need to read those again. It's fine. He made sure to include that.
Why did he copy these in like the world's smallest font?
I don't know. I don't know. So this is from Gingras to Greg, April 5th. So a few days before. Greg, one other quick follow-up, which I prefer to do in a call, but
Oh
happy to
my
leave this
God.
in email for now. So I just talked to Laura about the expert disclosure thing. I've said this before, but I am usually very robotic and pretty strict when it comes to following procedural rules. That means if everyone follows the rules strictly, I'm happy. And if people don't, I'm not.
Oh
With
my God.
respect to your experts, I'm guessing you really aren't planning to call them. There just isn't enough time. And if there is any value in their testimony, which I can't tell due to lack of detail in the disclosure, that value seems like it would be minimal at best. Plus the Dalbert problem, etc. But Laura and I are such reasonable people. We actually think maybe it would be okay if you really want to put one OBGYN on the stand. Obviously, I would need and am entitled to a lot more disclosure about what this person plans to say and what their backgrounds are. I obviously need to know if the doc is married to Clayton's brother or whatever. But assuming no other red flags, I may actually be willing to agree that you can call an OBGYN because I'm guessing if that person is truly neutral and knowledgeable, they can offer some valuable information for us. They sure can, David. They sure can. So, this is one of the issues I'd like to discuss, and this really shouldn't be too controversial. David. Oh boy. Oh boy. Right? Same cycle as Laura. Same thing.
So who decided that? Like, was it Laura that was like, okay, this is how you should handle this? And just tell Gingras? Or are they just really that similar?
I don't know. I don't know. So here's another one from David to Greg. Great. What do you have to say now? Oh, wait.
Yeah,
Just
Greg
read
just
those.
is like leaving all of these emails on red. And I guarantee I wonder if Laura did teach him how to set up that email tracker.
Probably.
I know you're not answering my emails, Greg. I can see.
I can see it, Greg. You've checked it 742 times since then.
I have called you 500 times from 13 different numbers, Greg.
It's not harassment, though. So this is Friday, April 5th. Actually, I don't think we read this one. So, Greg, I appreciate the response. To focus on matters at hand, we need to speak about the status of disclosures. This is one of the items on the list. I understand because they're about to have a trial baby together, you guys. I understand that a few days ago you disclosed the name of some experts, but basically nothing else. Obviously, the incredibly scant details of these disclosures do not come close to what it's required under Rule 49. And separately from that, I don't need to remind you. Wait, did we read this? No, we didn't. Okay. That if you want to call an expert, you also have to separately meet the Rule 702 admissibility standards and the other requirements of Dalbert. But they can't say anything until Laura fucking hands shit over. Oh, he's so frustrating. If you're not familiar with these requirements, attached is a brief where I explain them in some detail in case you've never practiced law ever, because I have. I mean, At the end of the day, since you have a total of 1 hour of trial time, I'm not really sure that I even care about this. I don't know if I care or not, but I'm gonna complain about it anyway. When you deduct time for a little opening, closing, and the main witnesses, if you really want to call an expert and use your remaining time, what, maybe 1 to 2 minutes per person, to ask a few questions, I guess you can do that. But that's only if you disclose everything that's required, which you haven't done, and only if you show compliance with Daubert in 702. Also, not yet done. Again, this is why we need to talk. I'll leave you alone for the rest of today, but we need to talk on Monday, okay? If I don't hear from you, I'm going to ask the court to order you to speak with me. So let's just try to work together collaboratively on this.
I thought you were going to say I'm going to have the baby.
Pretty much. Pretty much. And one last reply to this comment. I would certainly accept that apology. 2 things.
Oh my God.
1, yes, I absolutely do apologize if I was unprofessional or unpleasant. That was not my intent. And
Okay.
2,
That's deceptive.
2, you need to respect the fact that Laura has severe, and I mean extreme, concerns about your honesty and integrity. At
Mm.
first, I did not share those concerns, but since I've learned about this case, I'm starting to see that Laura's concerns may have merit. This is not how you'll get a top golf date, dated. All right, come on. If you don't fully appreciate my concerns, I will say one last thing. I know I already said that, but I'm going to say it again. I am about to send a long email to Dave Neal. I assume he's working closely with you, but if not, you should reach out to him and ask him for a copy of the message. Since you don't know me that well, the email may provide some helpful context. That's the main reason I'm sending to him. And I will tell you the same thing I told Dave. There was good reason to make some public comments to explain Laura's position, but that is now done. It's all done, guys. He's not gonna do that again. I don't plan on speaking much more about the case in public unless it's
Uh-huh.
necessary to
Uh-huh.
respond to false information someone else has published. Hope that
Uh-huh.
makes sense, David.
Where are we? How many years later?
Right? Oh, and finally, we got one from Woodnick here. I think this is the last one. So this is Friday, the same day at 1:40 from Woodnick to David. David, I have disclosed medical experts who would like to see the photographs, Planned Parenthood, and the telemed records about the alleged miscarriage as it may impact their efforts. Brian Neumeister is prepared to review the date as well. Please provide the disclosure and then we can discuss resolution options.
Uh-oh.
Goodbye. Goodbye. I appreciate that you say you will tone things down. But that is contrary to your recent blog posts and continued activity on Twitter. I respectfully disagree with you legally, but that is what the courts is for, not for the zoo-like atmosphere online. With regard to the YouTube and podcast crowd, remember that was actually created last year when Laura was posting and arguing with Redditors and sending ostensibly altered data to Steve Carbone and others. As for lunch, I enjoy food. I enjoy food.
Who doesn't?
In my 24 years of practice, I have never said no to a lunch or beer invitation. But I am saying not now. Perhaps this will be nothing more than fodder for a future blog post, but I trust you are being sincere. Your statements in emails, over the phone, on your blog, on your Twitter, etc., may have been the product of passion, but they were received as combative and unpleasant. Given your verbiage and your approach online and to my team, I think Judge Mata will side with me on any trepidation issues here. That said, I am quick to forgive. And if your email is meant to be an olive branch apology for the professional allegations and overzealous advocacy, I would certainly accept that apology. I want to avoid Clayton incurring fees discussing anything further without the disclosure, which I trust you agree is reasonable. So he sends like 17 more emails. We need the expert's input, and Clayton will make informed decisions with data your client provides. Greg.
He's just like ticking up the cost with all these
Right.
back and forth.
Oh, we got another one from David. Same
for
day.
fuck's sakes.
But this was before that message.
Oh,
Greg, I just tried calling your office, but got no answer. I think it's been over a week since we've spoken by phone. There are tons of issues that we need to talk about, and email just isn't cutting it. We need to talk soon. Since you and I are about the same age, maybe you saw this back when it happened. But if you didn't see this, I politely ask you to read Judge Gaines' famous order granting plaintiff's motion to compel acceptance of lunch invitation. Oh my God. Right now, we don't need to meet for lunch, although I am happy to do that. Right now, all I'm asking is for you to have the courtesy of accepting my call so we can talk about the case. Tone will be calm, friendly, and professional. If you won't agree to talk, I guess I will ask Judge Mata to order you to accept an invitation to lunch. Wow. In there, he says that little screenshot. Oh, there's another one. There's another one from the day before. From Greg to David.
how many more?
We're on the last page. So this has to be, oh, this is it. This is it. We've made it.
You said that 2 emails ago.
I know. David, one, while I appreciate your right to speak on all issues, I am deeply uncomfortable with the tone you are using in emails to my office, on Twitter, and in your blog.
We've heard this one.
Oh, we already read this one. Yeah, he says he's never tweeted before, blah, blah. Okay, now we have some more exhibits and then we're done. But they're not emails, guys.
That was just exhibit 1.
Yeah. Now we have David's tweets, apparently.
Oh,
So
this could be fun.
Yeah, these could be fun. These will be very fast. I don't know
And
when
short
they're
because he gets a character limit.
Yes, which we know pisses him off because he wrote about it in his blog. So he says on Twitter at some point, X, whatever, new motions filed yesterday, 4/8/24 in Owens v. Echard. I'll probably post a short blog update later this morning. Cool story, bro. And wasn't he complaining about how court documents were being given to the public? Okay. So for now, onward we march. I don't know where this is from, but anyway, so for now, onward we march. Absent a last-minute settlement, which is probably the most likely outcome, we will have a trial in June, and the judge will decide who is lying and who is telling the truth. The only issue not up for debate that day is the bullshit motion for sanctions that Clayton filed in January and which he has now withdrawn. And that is a good thing. David. P.S. As I get more, we've read this part on his blog. As I get more up to speed with this case, I am really starting to lose patience with the small
Yeah.
but vocal handful of people out there who are milking from the little teats of this case for personal financial gain. I'm not one of them since I make $0 from writing this stuff. You, the guilty and the dirty, know who you are. How dare you? These people, not naming names, are generally blogging or hosting YouTube videos every day to talk about the videos, every day to talk about the case, but they are not really talking about the case. Not even close. They don't explain all the facts and they don't give both sides of the story like any real journalist would. At the end of the day, they don't give a shit about this case, and they don't give a shit about the people involved or the truth. They are nothing but mosquitoes sucking their meager livings out of the First Amendment I fought so hard to protect. These human leeches are selling half truths and twisting shit way out of perspective in order to increase the drama. So much drama. And thereby get a few more pennies of Google AdSense revenue and a few super chat bucks to pay for breadsticks. It honestly makes me puke. Fuck these sick, selfish, lying assholes. Should I clarify how I feel? These vile scum, people are not helping anything. They are human cockroaches spreading feces on the floor. I know we've read this so many times, but I think we should embellish it every single time we read it because he's so fucking dramatic. It's ridiculous. And then spinning the facts to make them more dramatic than they really are in the hopes this will drive traffic and increase revenue for their sad, pathetic lives. One day, these trash humans will wake up and realize that lying for money is not a good way to live. And you should know he's a lawyer. Or maybe, I'm just kidding, not all lawyers are liars, but let's be honest with him here, okay? Or maybe they will never see their sins. Either way, I look forward to reading their obituaries briefly before throwing them in the trash where they belong. Here's a post from David. Thanks for the $1. When I go the casino tonight, I'll put it on the roulette wheel and let fortune decide my fate. Okay. Also, I don't plan to make further public comments for now. The process was helpful, but not productive. Moving on to other tasks. So social media is never productive. Okay. I don't know what you were thinking, but it never is. Here's another one. I am commenting because there is a huge amount of misinformation being spread unfairly about Laura. The purveyor of these lies will likely be sued in the near future. Oh, David. For now, I am trying to correct the record and help people understand the law. I'll blog about that ASAP. Then he says, just look at Alex Jones. He spread lies about parents who lost their kids in a school shooting. He was sued, couldn't prove his lies were true, and a jury awarded him to pay $1.5 billion. Anyone who thinks it's funny to spread lies better own a tent and a sleeping bag. Ugh. Well, your client has charges for perjury, so and pretty soon she might just only have a tent and a sleeping bag. You are a prophet, sir. All right. And what makes you, this is at Court Watcher 123. And what makes you so confident you know the truth? Were you there when Clayton and Laura hooked up? Have you seen all her medical records? I have. And trust me, the people who have accused Laura of lying are probably going to end up sued for defamation. I'm not talking about you. Where's those lawsuits now, David? Where's Laura now, David? Where is she, David? This is Kim at Medicare for All. I don't know how Twitter works. I think it goes down and then up. All right, we'll read David's, then goes up. Here for the long haul. Don't believe me? Let's bet. I'll bet you $1,000, my own money, that I will be here through the end of this case. Want to take that bet? Message me and we will set up escrow for the wager. I won't hold my breath. Did anything happen with that at all? Did anybody? Probably not. He's like, oh, I was just kidding. I was here the whole time. Ken says, nah, they can refile anytime. This guy won't be around long anyway. Okay, so he was replying to her. So judge is going to chew him out and spit him out. Okay, I see how this works now. Is that a yes? Oh, wait, he's replying to Flowers Are Red and Gail Wysock. Is that a yes? Put your money where your mouth is. We both know you won't. Enjoy troll life. Hashtag sad.
Well, 2010.
Oh my God. It's so like, this is so like elementary. Oh, really? Well, put it where your mouth is. A double dog dare you.
I know you are, but what am I?
Then Kim says back, don't need to. I can watch you fail and laugh. David, then another time, says, hang on. Several people posted a shame on you for posting someone's name. I have no clue who they are talking about. Now you're saying you went nothing confidential? Okay, which is it? All confidential or nothing? Again, Laura asked for confidentiality and Clayton said no. I wonder what this is in response to. And, oh, this is David replying to Megan Fox Ryder. And yes, of course, I read my own emails. I have no idea who Blink is. No idea why he would need to be shielded from public view. Clayton's lawyer could have told me that, but never did. Oh, that must be the one guy that doesn't want any attention. If this crazy talk continues, hard blocks will follow. Seriously, stop. He means business. Why is X being so mean to him? It's such a nice place. You all are going to get in trouble and get blocked. Oh, no. David, back to Megan Fox Ryder. For like the 99th millionth time, Laura asked for a protective order. She asked for the court to say that certain stuff should be private. Clayton opposed this. He wanted nothing to be private, and the court agreed. If you don't like that, tell Clayton to change his view. But wasn't that about like her she had specifically asked about medical stuff, but okay. He is just so cool, isn't he, Doug? He's just so cool. He's regressed like a high school girl, right? Oh my gosh. I'm rubbering your glue. David, don't like my bio? Ask for details. I'm the Conor McGregor of litigation. Done tons of family law cases. I don't list those because they are boring. FYI, Clayton's lawyer has handled 2 federal cases. High-profile cases go to federal court. Me, 79 federal cases and counting. Court Watcher says this to him. You've said yourself that you are trying to get up to speed with this case. There are people posting replies to you that know this case inside out. Every court document, every televised court hearing, every article Lowe has written about this. Why do you assume they are lying? Oh, David, what you going to say? David says, and put all the noise aside. Laura had multiple positive pregnancy tests before she filed this case. Not 1, not 2, multiple positives, including one purchased by Clayton and taken directly in front of him, which was positive. What else really matters? David. You are dumb, David. The only remaining issue in the case right now is this. Did Laura lie about being pregnant? Yes, I'm still new to the case, but the evidence on that point appears to be 10,000% clear. She took a pregnancy test that Clayton bought in front of him. She's not a magician, guys. How is that not conclusive? I'm not assuming they are lying. That isn't how this works. Clayton has a duty to disclose admissible evidence to me through his lawyer. I get to look at that evidence and determine what it means. Views of strangers on X is not admissible evidence. I don't think that's what they're telling you, David. They're telling you go look at the actual evidence of things. They're not saying their tweets are the evidence. They're just telling you go look. That's where the evidence is. Go read it for your
He's
fucking self.
he's being intentionally obtuse.
Obtuse, you douche. Obtuse. I mean, come on. Don't be ridiculous. Cold tea says it's pretty simple. She has already admitted to doctoring ultrasounds. She never saw an OBGYN who performed an ultrasound. That is the only way to confirm twins, period. The woman lawyer was the fastest to piece out because any woman worth her salt can see right through this. Exactly. David, the woman lawyer took a job in another state. Her leaving had nothing to do with Laura, which is why Laura filed a bar complaint on her. But okay. And Laura has testified she did have an ultrasound. She admitted to changing the name of the place where it was done. Bad idea, but she stands by her story. So what if it was twins or not? What do you mean? So what? A woman can file a paternity case with a 0 positive test. She can file the case just because she missed a period. She can file the case just because she thinks she might be pregnant, even if she ends up not pregnant. It's not illegal to ask courts to help verify paternity. No, but it is illegal to lie to the courts, to fabricate evidence. It's illegal, David. It's like a big deal, David. A big fucking deal. Oh my God. And if you feel a positive lab test doesn't prove anything, that's fine. That is your opinion. I respect that. But legally, you are wrong. Medical tests are admissible proof. Bearing in mind, there is no legal requirement that Laura ever test positive before going to court. That's not what people are talking about, David. For fuck's sake, David, I thought you were smart. You're being stupid.
It's intentional.
One step at a time. Laura went to an urgent care. She asked for a pregnancy test. They took a sample, sent it to the lab, and the result was positive. Let me explain as clearly as I can. I already read that one, didn't I? No, probably not. This case is not about Laura offering 1,000% confirmed proof she was pregnant. That is not an issue here under the law. The only question is, did Laura have some reason to think she might be pregnant? That's it. That is it. If so, we win. Okay, but you see, though, your client's a fucking idiot. And she committed perjury. She changed the timeline. She followed falsified documents. Like, come on. That's why she's in trouble. So, because she's a fucking idiot, and you know it. Bottom line, Clayton's cult hates Laura because you do not understand what is going on here, you fucking idiots. He didn't say that, but he was thinking it. I'm pretty sure. That mistake is making you see the case incorrectly. I'm trying to explain and clarify so you understand, but people are not listening. That's fine. I will keep moving forward. The only person that can explain it to us is him, you guys. Doesn't matter if she never had an ultrasound. Doesn't matter if she faked an ultrasound. I think it does matter. Doesn't matter if she never sought OB care. Doesn't matter if it was twins. Doesn't matter if they weren't Claytons. At some point, you'll catch up on how this works. You're not there yet, you fucking idiots. Oh my God.
What? So it doesn't matter that it's Clayton's. I think it does. I think you
Yeah.
actually have to be pregnant. Like,
Right? I think there's a word
don't.
for that. Frivolous, maybe? Is that I think it is. What other
I
legal arguments are there? Genuine question. Can you give the rules you'll be mentioning so I can look them up? Laura is also probably going to file one or more motions for sanctions under a bunch of different rules and laws. Don't ask for details. Don't ask for details because I don't have them. That will come when the motions are filed, if needed.
that will come after I actually read the documents.
Right? Core Watcher says, I'm intrigued by what sanctions Lowe will be requesting.
Court watcher, who are you?
Who are you? If he does not withdraw the motion, the rule gives him 10 biz days. Then we will file a motion for sanctions. Rebecca says, I'd be interested to hear what piqued your interested in posting updates about this particular case versus other cases you take. Good question, Rebecca. I think that's a good, fair question. Let's see how he responds to this. I'm sure it's great. Main thing is because one party is aggressively making public statements about the case, and Laura feels her story is being drowned out by misinformation. That is a problem that needs addressing. So I've decided to post some info to try and clear the air. More to come soon. Oh, thank you, David.
She did that. Oh my God.
Right? Jess says to David, I'm sure you will, just as her revolving door of previous lawyers got there. Good luck. David says, in this case, one lawyer left to take a new job, and the second guy left after Clayton's lawyer threatened him. Poor guy was young and not ready for battle. I am ready for battle. I'm not going anywhere. So weird. Jody Nish says to David, attempt to get someone to sign a relationship contract 2 weeks after they allegedly raped you is insane. And David says, if that is what happened, you may have a point. Okay. Or maybe you only know like 3% of facts, and forming this strong of an opinion based on 3% of the facts is honestly fucking stupid. Those are his words.
So then what are the facts? Because that's what I understand based
the
on
Facts, David.
what are the alternative facts?
All right. So then he goes on to say, if you can show me how Laura lied, I would drop her as a client instantly. Bull fucking shit, David. If you mean what you say, you'd be open to helping me understand the truth. That is all I ask. No, you don't want to hear it, David. Shut up. You're a liar. Stop it. Stop it. You don't want to hear it. You know you don't want to hear it. If you turn your back on my request, what does that say about you? About your true motives, huh? Flip it back on them. Great job, David.
What an idiot.
I know. You are my sunshine, responds back. She had the DNA test done more than once, and all results said little to no fetal DNA. Doesn't matter when she miscarried, as fetal DNA lives in mom's blood for months and sometimes years after miscarriage delivery. This is definitive proof there was never a pregnancy. Oh, great. Can't wait to see what David has to fucking say about this. Great analysis. Just one thing. Do you have a pic of the time machine Laura used on 8/1/23 to go forward in time to 10/15/23? See these test numbers? Then travel back to 8/1/23, where she proceeded to maliciously file for paternity, knowing what the future held? Please send pics. What?
What?
The time machines? David, shut up, David. Whatever, David. You're ridiculous, David. Oh my God. Oof. Well, thank God that makes us done for the day. I am going to need all weekend to recover from all of that. Holy shit balls, guys. Wow. Just wow.
And you didn't even drink.
I didn't even drink today. I don't even think my brain could handle it. It was just like, what is happening? In other words, he thought he could get internet. Famous.
Yeah, I actually think that's true.
He wrote this after the deposition, right? Laura's? Yes. Yeah, because that was at the beginning of March. It was like March 1st, and he came on, what, March 25th, I think it was. So, yes. Yes, the dating contract sent by Grind. You guys, there's no proof. All right. And if he thought his client was lying, he would quit, even though literally everyone has told him she's lying. And here's how obvious it is. But, mm. They need to offer you guys free therapy for this. No, I do talk to my therapist about this.
I need therapist now.
On Wednesday, I did, because she was like, I was like, you have to listen. Okay, listen. What is wrong with this bitch? Okay. No. Well, you guys, that's what we got for you today. So I can tell you that our Clayton's costs, which are a little messed up, but whatever, we'll go through it anyway. Oh, I'm not even on the right. Share this instead. Oops, I think I went too far. There we go. We started today with $65,091. Right? Yes. And we did the eighths the other day, so it's really just $1,524 to the end total of $80,993.50. So, yeah. I don't know.
$1,500 in just one day.
By the way, the math on these slides is all different because I had to shift everything this week. So you're like, the total is this. That's not right. Just I don't know. It got into a big mess today, or this week, is all I can say, with things
Yeah,
moving
because things
around.
got moved around. Yeah.
Yes. Let's see though, before we go. That was an interesting day. Another call to action, anybody that wants to be a part of our June 2026 Mega Stream fundraiser for Mike Maricini, please get in touch with me over the weekend. My email is Tara, Tara, at tcwtmedia.com, or you can reach out to Winks. We're also both on Discord. I'm not a drama llama on Discord. Reach out to me if you can help in some way, whether you're a creator, an advocate, I don't know, whatever you think you can help, get in touch with me. So what are we going to be covering when we come back next week?
Can't wait to see what else David has in store for us.
Well, it looks like there's a request for judicial notice, a reply from David about lunch.
Oh,
So I'm sure
my
that's
God,
great.
we're still on lunch.
Yes. He's still on lunch. And then, Laura complains to the government because she wants to withdraw her name change. She wants her fees refunded for that. And they haven't given her an answer
Again?
yet. So no, she's checking back in because she didn't get an answer, I think.
She didn't get her $50 back?
Didn't get her $50 back. And then it looks like we got some Jingrits blogs and whatever else we end up getting into. It's going to be a very, very busy week of craziness. Oh my gosh, there's so much. An amended motion of relief from just judgment based on fraud, a petitioner's response to Clayton's amended motion for relief based on fraud. Oh, that'd be from Laura and Gingras. Oh, I can't wait till we get to that. So that we'll be covering that next week. Now we won't be live again until Tuesday at 10 a.m. Eastern for some more of this craziness. I'm shocked. Laura complains. Never. There were too many Rule 26 missions. People are drinking our best up by now. Right. Well, I know it was a long one today. Thank you guys for sticking it out with us. Recover this weekend. Try to recover those brain cells we all just lost from those shenanigans. I cannot believe how much he's like Laura. Like those emails to
yeah.
Greg.
Yeah.
Whoa.
It's crazy. I know people said that they were like twin flames. I just guess I didn't really realize how similar
Right?
until like it's all laid out like that. And then you're like, wow.
Whoa. Holy
The
shit.
MO is exactly the same. That's wild.
Yes, happy birthday to And I'm Some Lady and Katie4296. Thank you guys so much.
I
If
hope you'll have the best birthday.
I know, right? Yes. If you are watching this as part of the replay crew, make sure you've liked, make sure you've subscribed, make sure you've hit the notification
Oh, the internet decided it didn't want to listen to you anymore.
channel and getting us out
You
there.
cut out.
Oh no. I was so good with that one too. Oh, fine. I'll do it again. Replay crew. Replay crew. Please like, please subscribe, please hit the notification bell, please hype. And also leave us comments for us to read over the weekend because we want to hear your thoughts, especially about David, because we'll want to talk about it all weekend still. So thank you all for being with us today. I hope you all have the best weekend. And until next time, go forth and be amazing. All right. Bye, friends.